My calculation on 22.
Therefore, listing, please give it to the court master. 22,
Yes.
because we are now in a
Last
difficult
day.
situation.
I understand that, but some others.
And not on 22, 23.
23 of license.
Lordship, in item number 9, your lordship,
Yeah.
we had filed an IA for vacation of for clarification of an order, your lordship.
Okay.
So that IA is not listed today. May I pray that IA also be taken up, your lordship? I have otherwise.
May it please your lordship. So
Yes.
far as item number 1 of the part 2 list is concerned, madam, I'm on with the authorities, and since the matter is there, my colleague is also there, let the matter be on the list, let it not be taken up in few days, madam. Because we are working on it. If we get it, it's the end of the issue. Otherwise, it may proceed. That's why. He's there. I've told her.
May I please your lordship, I beg to mention for listing.
Listing, give it to the court master.
Yes.
For listing.
Please your lordship, actually I beg to mention for listing lordship on 23rd. Say contempt case lordship.
You've heard what I was saying? You've heard? Any difficulty in hearing and understanding
No, lordship.
what you hear? Please do it.
So lordship, I beg to list one WPC 6130.
I'll disallow. Just now you heard what I told her, and you don't take, you don't pay attention. So your appeal is refused. Yes.
Daily list item number 1.
May it please your lordship. And I'm making this clear on behalf of Mr. S.K. Kejriwal, my lord. He is in bereavement, my lord.
Oh, yes. Yes. Father expired.
Yes, my lord.
Uh, Both sides are duly represented. On behalf of Mr. S.K. Kejriwal and counsel for the petitioner, therefore adjournment is made as his father has expired and he is in bereavement. First of all, under such circumstances, matter stands adjourned today. Mr. G. N. Savala, standing counsel for NGC, is present.
And a senior counsel, my lord, not a senior counsel.
Senior counsel, sorry. Senior counsel, assistant Mr. A. N. Singh, counsel for the ONGC is present. When should I fix it?
Any date, my lord, I think
Vacation
it will be after vacation.
After vacation.
Well, immediate after 18th, it will be fixed on 18th.
Okay, 18/7/2023.
Yes.
My lord, regarding
What is it? May it please your lordship? This case has become infructuous because the tender period was from 2013 to
becoming
20.
the council becomes elevated.
Sorry.
Council become elevated.
Okay, Mr.
K. Uddin.
K. Uddin, and counsel for the petitioner, as well as Mr. H. K. Sharma, learned- H. K. Mahanta, learned, counsel for respondent number 4, and Mr. P. Sharma, learned, standing counsel for AFDC, appearing for respondent numbers 1, 2, and 3.
I don't have the.
Okay. No, for 2 and 3, 1 will be government advocate, Mrs. Sharma, learned, government advocate appearing for respondent number 1. Next, the matter relates to tender for settlement of fishery for 7 years period from 2013-14 to 2019-20. First off, hence by passage of time, the matter has become infructuous. Accordingly, this repetition stands closed, having been rendered infructuous.
Three,
May I please your lordship?
Yes.
Lordship, in this writ petition, my lord, we are challenging the impugned demand order dated 28/7/2005, which was issued by the respondent number books.
That's CDC.
Lordship, in this case, Mr.
CDC.
A. Bokotiki is appearing. He has filed his affidavit in opposition.
No, I don't think now private counsel appear. Okay. Yes,
Shall I continue?
yes.
In this writ petition, my lord, we have challenging the impugned demand order dated 28/7/2005, my lord, issued by the respondent number 4, which is a demand notice for levy of penal fee on the allegation of excess weight detected at Rangapani Weighbridge. My lord, the impugned demand is at annexure 1. At page 38, my lord. My lord, this petition is, my lord, this matter is a third round of litigation, my lord. In the first round of litigation, the petitioner have preferred WPC number 5597 of 2005. In that petition, my lord, our bank guarantee
No,
for
you see,
covering.
this matter has become infructuous. The bank guarantee was for a limited period that has expired. There is no order of the court to extend the bank guarantee.
My
You,
lord,
you have not extended the bank guarantee.
we have again, we have extended the bank guarantee, my lord.
Where is that?
That was
That is
submitted
something I
before-
did not find. Where is that?
Lordship, that I need to consult with my client, my lord.
We'll take it up after some time.
Yes,
But I don't find anything here to show that the bank guarantees were extended.
Let me have a word with my client, my lord. Kindly-
Yes, we'll take it up after some time.
Yes, ma'am.
I'm sorry, my lord, I'm late. my lord.
I am of the view that this matter has become infructuous because of the fact that I did not find anything here that the bank guarantees were extended. So if the bank guarantee is not extended,
That was-
then you'll have to take recourse to whatever way you want to realize it. So please have a word if she's we'll take it up after some time.
Yes.
She says that she would confirm from the petitioner.
That's it, my lord. Actually, this case is also very old, my lord.
No, I understand, but you can have a word with the railway authorities and take it up
Lordship, I'm there.
at 2 o'clock, because we'll need some more time.
Yes, ma'am.
At 2 o'clock, we'll take it up. Because if the bank guarantee has been has lapsed, there's no point deciding these matters. We'll have to take recourse to
Other matters.
other measures.
four more, sorry.
Lord, can this matter kindly be taken up after some time?
This village forest,
Yes, sir.
May I indicate one thing, my lord? We are relying on a recent judgment of coordinate bench, my lord. That judgment has been put to challenge in an appeal, my lord. Last Friday it was listed, it was adjourned. Perhaps we may wait till the disposal of the writ appeal, my lord. Otherwise, my lord, to the extent of repugnancy with the other present laws, my lord,
you are relying on which law,
my lord,
which case law?
there is recent judgment of this honorable court, my lord. We had given a copy, my lord, WPC 4775 of 2022.
4775, yes.
Herein, my lord, the honorable coordinate bench, my lord. That's this forest rules, my lord, and held to be, my lord, in conflict with other laws. So my lord raised the query, my lord, what will happen under Article 372, my lord. So in a nutshell, my lord, forest and environment was earlier under the state list. In 1977, it is now after 1970, it is in concurrent list. Exercising power from that entry, my lord, Union legislature, my lord, enacted Forest Conservation Act and Forest Rights Act of 2005. Forest Conservation Act specifically mandates, my lord, it says notwithstanding anything contained in any other law for the time being in force, a forest land cannot be used for non-forest activity unless concurred by central government. And secondly, Forest Rights Act say there are some rights for the traditional forest dwellers and scheduled tribes, wherein these parcels do not fall. And therein also, my lord, they have to put in 3 generations inside a forest. That 3 generations is to be counted reversely from 2005. So they have to establish that they're residing inside a forest since 1930. Plus, my lord, they are traditional forest dwellers. So in that view of the matter, my lord, there are certain provisions under the rules, forest management rules, my lord, they come in conflict. So though it is a pre-constitutional law, my lord, to the extent it is in conflict with the constitutional mandate, my lord, and the laws framed thereafter, my lord, it will be impliedly repealed, my lord, to that extent. Not the entire rule, but the claim for settlement. Or, my lord, we may wait this judgment. It is now assailed before Honorable Division Bench, my lord. That is in Writ Appeal 213 of 2023.
So at least till what do you call 19th of July, which are the vacation period, you don't evict them.
We'll maintain status quo, my lord, as well.
Hmm.
Because I have also seen, my lord, they are producing some documents as old as 1922. Or one other thing can be done, my lord, if they agree. Let them make application before the DFO claiming their rights, my lord. He will examine, my lord. Till then, they will not be evicted.
Just wait for some time that Mr.
My
Broderick will come.
my
He may
lord,
not be,
my
so they will not be able to take a decision.
My lord.
Okay, after some time. You just surprise Mr. Broderick of what the Advocate General, Additional Advocate General is saying.
Item number 5 for admission.
And in this case, I'm appearing for private respondent. We have got some documents only yesterday. We need to file an additional affidavit. So we'll be filing it within a period of 1 week. Let the matter come up on 28th of next month for hearing.
It has to go after vacation.
Yes. The Lordship may admit the matter since it has come for admission.
Yes. But Mr. H. Burra Goel and counsel for the petitioner. Petitioners. Mrs. S. Sharma, Leonard, Government Advocate appearing for respondent number 127. And Mr. D.D. Das, Leonard, Senior Counsel assisted by Mr. HR Das, Counsel for respondent number 8. Next one. The Leonard Senior Counsel for the private respondent submits that he has received. He has been instructed that the respondent number 8 has been able to procure certain documents which he intends to file by way of an additional affidavit. Next, in view of the in the issue raised in the present petition, the petition stands admitted for hearing. by issuing rule determinable forthwith without requiring the petitioners to take fresh steps. Liberty is granted to the respondent number 8 to file affidavit in opposition. That is a week prior to the next date of listing. Next para is for hearing on 24/7/2023.
My lord, I'm deeply obliged.
Seven to nine.
Made to the lord.
Just a moment. Mistake could be possible. Just a moment, there's a mistake in last order.
Yes, my lord.
Uh, seen the office note in WBC 1732 of 2023, wherein it has been mentioned that due to inadvertent mistake, instead of implementing run-up DECA, the applicant in IA Civil 975 of 2023, the existing respondent number 5 has been implemented.
Yes,
Full stop. It is observed that the mistake is inadvertent. Hence, the registry shall implement the applicant in IA Civil 975 of 2023 as respondent number 5. Sorry, it will be 4. 4 was implemented as 5. Did the applicant in so as respondent number 5 in the connect in this repetition. Stop. Necessary steps shall be taken by the registry to delete the erroneous party implemented as respondent number 5. Okay. Yes.
Made to the lord.
Ah.
My lord,
Which
I'm-
matter you want me to take first?
My 760, my lord.
760.
Of 2023.
Okay.
That is.
Lordship, my submission with that matter, we are seeking instructions whether that is still effective or not, that tender process. Because in both cases, they have challenged the insertion of the finance turnover clause. The season is already over, whether the department would further want to proceed with that or not. Let me take that instructions. Lordship may take the other matter because the main issue is same.
Okay.
That is regarding the Napier seat. That case is still alive.
Okay. 760 you want an adjournment.
2215.
760 you want an adjournment. $761 deferment.
Yes, that one, the other one, yes.
Okay. Yes,
My lord, in that case, my lord, if my learned senior friend is seeking for adjournment, my lord, because as I have.
I'm not
submitted
seeking adjournment, Lordship.
For,
This case is more effective because that case, Lordship, finally, whatever decision, that may be for academic interest only.
no, let
Yeah.
me understand what he's trying to say.
my lord, on the last occasion, as we have submitted before your lordship, that these three matters are intrinsically connected only on the issue that has been raised, my lord. Otherwise, the facts are totally different, as I have admitted, my lord. Now, if your lordship, my learned senior friend seeks an adjournment for, or wants to obtain instructions on this matter, then the other matter, if it is heard, my lord, again, an endeavor would be made by this honorable court.
Then in that case, Lordship, all the matters may be taken up today, no difficulty. If Lordship feels that that particular clause is valid, after that also we may abandon the
Cancel
tender
or abandon
process.
the project, my lord.
Okay, the Advocate General has considered. You may proceed.
I'm obliged, my lord. May I?
Yes,
My lord, my lord, the writ petition 760 of 2023, we have basically challenged, my lord, noted, clause, my lord, which basically renders us ineligible. That is the turnover clause. And my lord will find it at page 72, my lord, is the NIT which was floated, my lord. Page 70 is starts effectively. May I read, my lord? My lord, this has been floated by the Agriculture Department, my lord, for procurement of, my lord, maize, my lord. And the date of commencement was 21st of January 2023. And the date of acceptance or submissions of bid was fixed on 10 to 2023. Then, my lords, may come to page 72, my lord. At page 72, my lords, this notice inviting tender, I will only read the relevant part, that is, my lord, point number 1 and 2, my lord. Now, point number 1 says, the government of India has received financing from the World Bank towards the cost of Assam Agri-Business and Rural Transformation, APART project, and it is intended that part of the proceeds will be applied to the eligible payments under the contract for supply of maize seeds. My item is maize seeds, my lord, to be supplied by us. Now, the Director of Agriculture on behalf of APART projects now invites online bids from eligible bidders for supply as shown in the table below. Now, your lordship will see that the name of the crop is maize and there are certain varieties mentioned, my lord. Now, these varieties can be divided into two parts, my lord, which I will come to on a subsequent corrigendum, which they have supplied. My lord, two varieties are, my lord, biofortified maize, one variety, one category, and hybrid maize is the another category, my lord. Now, in this particular NIT, if your lordship sees, total quantity is, my lord, 6,25,000 kilograms. So this is the total quantity we need to supply. And the period of delivery is, my lord, 15 days. That is from the date of award of the contract. This 6,25,000 has to be supplied, my lord. Point number 3, it says bidders will have to quote for the entire quantity of bid quantity as further defined in the bidding document. Now, my lord, at paragraph number 4 are the dates, which I will skip, my lord, which is not important. And this particular process, my lord, consists of two parts, this online process. First, the submission of technical bid, and then the financial bid will be open. However, my lord, the financial bid will not be open on the particular date when the technical bids would be open, because there is a categorical mention about that particular aspect at clause number 6, my lord. I will not again read that clause 6, my lord. Now, my lord, the current petitioner is basically eligible to participate as he fulfills most of the condition, in fact, all the conditions to participate in the tender process. So he prepared himself to submit the tender papers, my lord, accordingly. But when he
What is,
perused,
what is the, what would be the estimated cost of
Yes,
6,25,000? What
Yes.
is the estimated cost?
they have not given, that is a very pertinent point your lordship has correctly pointed out, that has not been mentioned in the initial bidding documents anywhere, my lord. The value of the work in question, that is 6,25,000 kilograms of maize seeds, what would be the value? And more so, when there are two categories of maize, they have, my lord, invited tenders for procurement, my lord. Now your lordship may kindly come to a condition, my lord, which has been impugned herein in this writ petition.
4 crore.
Yes, my lord. At page
Yes.
number, your lordship will find of the writ petition at page number 102. 102 is the impugned provision, my lord, which we have challenged, my lord. May I read, my lord? This broadly has been categorized as section 3, evaluation and qualification criteria. This section contemplates the instruction to bidders. It contains.
Just a moment.
Yes, ma'am. May I take my lords to page 102, my lord?
Yes, I'm there.
Yes, ma'am. So here, my lord, the basic criteria or the qualification that is required has been envisaged, my lord. So, my lord, may kindly come to page 103, my lord, the technical part qualification, which reads, my lord, if I may read, my lord.
Yes.
The first part is for a company or producer who should have the following qualifications in order to be eligible, my lord. So first part, it does not apply to me, my lord. I am an authorized supplier under the state government, and my company authorizes me to supply. And in this NIT, under this current clause under which we have assailed, my lord, we are also a category of bidders who should be authorized by their company to participate in the bidding process. So, my lord, qualification 1.1A, if it reads as such, if the bidder is a company stroke producer, the financial capability, just first line I'll read, my lord. The bidder should have an annual average turnover of 15 crores in the last 3 financial years, that is 2021, 22, 2021, and 1920. So this doesn't apply to me. Now the provisions which applies to me, my lord, is B, my lord, B. It says if bidder is an authorized supplier, I'm an authorized supplier. Now it reads as follows, my lord. If a bidder is not a company producer, but is offering the seeds on behalf of the company producer under company's authorization form, section 4 bidding forms, the authorized supplier shall demonstrate the following qualifications. Number 1, bidder should have an annual average turnover of 4 crores in last 3 financial years, that is 2021, 22, 2021, 1920. My lord, I would like to just pause here for a while, my lord. Now they are seeking financial turnover for 3 years, my lord. So this is very essential. Now, in normal understanding, my lord, 3 years would include all the financial years that they are seeking. Meaning thereby, my lord, a consistent, my lord, 4 crores of turnover has to be there for the bidders to participate. Now, in this case, my lord, if the bidders do not have 4 crores consistently, uniformly for all the 3 years, they will not be eligible. So my client, they do not have a consistent record of 4 crore in all the 3 years. I could go through some of similar provisions relating.
You see, what you call,
Yes, madam.
if you care to open your mobile and just search for the price of maize seeds,
Yes, my lord.
you will find that average market price is 80 rupees per kg.
Yes, madam.
Internet, just open your mobile, I won't mind. Technology is no issue.
Yes, my lord.
So price of maize
Yes, my lord.
is 80 rupees per kg.
Yes, my lord.
So if you are buying in bulk, maybe some here and there.
Yes, my lord.
So the average cost comes to rupees 5 crore. It is 625. 625 into 70 would be about 5 crore.
Of course, my lord.
Just do that calculation. I may be wrong. Oral calculation is always questionable.
No, my lord.
So therefore you see 5 crore is the turnover. So asking for a average turnover of 4 crores, how it is so bad?
Yes, my lord. My lord,
Subsequently, it was reduced to 3 also.
Yes, ma'am.
It was reduced to 3
It was reduced to 3.
3 crore.
after the pre-bid meeting.
I'll come to that. Now, my lord, as your lordship has correctly stated, my lord, we also made an attempt when we saw that there has been no quantifiable amount or price or the value mentioned in the tender document. We also made an effort to find out, my lord, what would be the value of the work in question. So in my petition, I have stated that the current value of these 6,25,000 kilograms of maize seeds, my lord, was approximately, it was estimated around, my lord, somewhere around 6 crore and 25 lakhs, somewhere around there. But I'll come to this part later on, my lord. But there is a different aspect involved in this, my lord, which your lordship will see in the corrigendum. What they did, they divided this quantity into 2 parts. Now, my lord, I'll come to the corrigendum, my lord, if I have to put my point, my lord. Now, your lordship may kindly come. So in between, my lord, being, my lord, anticipating that the authorities would bring down the turnover, we filed some representation and they hold a meeting called pre-bid meeting. And in that meeting, we have put forward the proposal that you should reduce the turnover from 4 crores. Then, my lord, a corrigendum was published at page 165, my lord.
Yes.
At page 165, my lords, if your lordship comes, this is a very interesting corrigendum, my lord, they have published. On 4th of February 2023, this was published by them. It reads, my lord, the impartial modification of RFB issued by this office bearing number such and such dated 21st January 2023, that is the original NIT, for supplies made seeds under Assam Extension Program, World Bank Finance Apart Project. The following amendments are hereby made, my lord. Now, the first variety, my lord, the original provision, if your lordship sees, there was a limited variety, but amendment, they have introduced many other varieties and any other notified variety for the state of Assam. So they have enlarged the scale of variety, but fundamentally there are 2 categories, biofortified and hybrid maize. Now, my lord, at clause number 2, evaluation and criteria, the bidders will have to have an annual turnover of 4 crore. As my learned senior friend has said, my lord, they have reduced it. Bidders should have an annual average turnover of 3 crores in the last 3 financial years, my lord. Now, my lord, may come to clause number 4, earnest money deposit. This is interesting again. Initially, what they did, they have only thought the EMD required is only 10 lakhs without dividing the categories. Now, what they did, EMD required for biofortified maize is 24 lakhs and hybrid maize is 13 lakhs 50,000. Here, my lord, one thing I would like to point out, my lord, I am a supplier, an authorized supplier of only hybrid maize seeds, my lord. So there will be other bidders also who would be having the certificate of supplying such particular category of, my lord, the maize seeds, my lord. So here, I'm concerned only of hybrid maize seeds. Now, my lord, 13 lakhs 50,000 is the EMD I need to deposit. Then lastly, your lordship will see invitation for bid, the quantity they have also now divided. How much quantity they require, my lord. Total quantity in the amended provision, it says in kilogram requires as follows. Biofortified, they require 4 lakhs. Hybrid maize, they require 2 lakhs 25,000, my lord. This quantity is extremely important to decide the issue in hand, my lord. This hybrid maize, they have reduced, they haven't reduced, they have categorized and they have brought it under a quantum of 2 lakhs 25,000, which means, my lord, the value of 2 lakhs 25,000 hybrid maize will have to be made known to the bidders. Number one, they have not till date. Number two, for biofortified maize, similarly for 4,000 kilograms of biofortified maize, how much would be the contract value of this particular 4 lakhs kilogram of biofortified maize, my lord? Now, my lord, interestingly, again, my lord, when the matter was before this honorable court, the authorities came with the affidavit. I will not burden my lords reading the my lord, the entire petition, but I'll just quickly take your lordship to the affidavit in opposition filed by the respondents, my lord. Kindly, my lord, may come to the affidavit, my lord, of the state government. For the first time in their, my lord, affidavit, they affidavit filed by the director, my lord. It starts effectively from page 201, my lord. May I take my lords? Yes, my lord. Affidavit filed by the respondent at page number 202, paragraph number 2 is relevant, my lord, for this. Now, what are the reasons? And for the first time, they bring it before this honorable court, the quantum and the value of the work in question, my lord. Here it is, my lord. Now, I'll skip the first part, which they say it is a World Bank finance project, my lord, and the procurement guidelines of the World Bank are used. I'm reading from in between, my lord. The bidding documents dated 21/01/2023. Have my lords found, my lord? The bidding documents dated 21/01/2023, section technical part qualification, point number such and such stated that bidders should have an annual turnover of ₹4 crore in the last 3 financial years, that is 1920, 2021, 21-22. This is important. The tender value is estimated at ₹18 crore for 6,25,000 kilograms of seeds, and any bidder participating in the tender should have sound financial control to execute such high value contract. Without financial soundness, the successful bidder shall not be able to carry out the contract, and that too with strict deadline of 15 days, hampering farmers' interest as agriculture works are season bound. It may be mentioned that initially the turnover was kept at mere 22% vis-a-vis the tender value at the beginning. So they say 18 crore is the value, 4 crore is the 22% of 18 crore, my lord. What I have understood from here. Then again, based on pre-bid meeting held with the interested bidders, including the petitioner before the submission of their bids, turnover was further reduced to now 3 crores by a reduction of 1 crore, which is now 17% of the tender value. Meaning thereby, my lord, they have again reduced it, and 17% is the 3 crore of 18 crores. However, it may be reiterated that to execute a contract of 18 crore, 17 crore of the tender value is the least a tender inviting authority can ask. This bid is financed by World Bank, and usually, this is important, turnover is kept not less than 50% of the bid value. And to cite few examples, I'll skip this part, my lord. Fundamentally speaking, my lord, what they are trying to project is the 17% they are seeking from the total value of the work in question, my lord. Now, my lord, at paragraph number 6 is important of the affidavit. At page 205, my lord. That as regards the statements made in paragraph number 11, the writ petition deponent begs to state that more varieties of maize seeds has been introduced, as I have stated, by the corrigendum only on the basis of representation of the bidder so as to enable maximum participation. In fact, the earnest money deposit had been kept as minimum as 2% of the bid value, could range from 2 to 5% of each of the categories, which is a prerequisite for all tenders. My lord, here emphasis has been given to each of the categories which is prerequisite. Kindly see, lordship, how they have now. I'll try to show how they are contradicting their statement. While giving EMD, they
Just tell me, Mr. Buragwai,
Yes, sir.
what is the purpose of a pre-bid meet? If they remain adamant and don't change the clauses,
yes, sir,
what is the purpose of having a pre-bid meet?
of course.
They could have done a
Carry on.
tender, whatever is their conditions. After that, what you call, there's a series of judgments from
Of course.
2020 to 2022.
Very good.
We says that tender clauses are sacrosanct, we court can't interpret it. So if they have done it, they have taken a conscious decision after having a pre-bid meet. How can such decision be said to be arbitrary? Because you see, I'm bound by a series of judgments, including Monte Carlo.
Yes, my lord.
Where is the scope of interpreting the clauses of the government tender?
Yes. Well, I'll come to that point. Just lordship may give me 5 minutes. I'll read my.
No,
affidavit.
time is no constraint,
My
but
lord.
Before my learned friend continues, I have received the instruction. This program of maize cultivation is for the specific pre-kharif season of February till April 2023 on rice fallow.
so there
That
is,
period is over. However, the safe period is already over, and purpose of utilizing the program will not be fulfilled, and it will deviate from the prime purpose. So we are no more into this. So this will be an academic discussion only now. So this case
Okay.
lordship has no meaning. It has become interest.
so
So far
one,
as maize is concerned, the other case is alive.
so one, what you call, one opportunity to farmers is lost because of litigation.
Lordship, sometimes that situation comes. That's why it makes a lot of submissions before the honorable courts when the stay order is passed, when public interest is involved.
My lord,
yeah.
I was, my lord, because of this, I'm not for maize per se, I am for bio-45 maize. There was an order also filed, my lord, but they objected. He was no way connected with bio-45. Because of this stay order, today, my lord, my tenders, my bids have become infructuous.
We brought it to
Who
the
will
notice of the
compensate
court
me for
earlier.
that? No.
We brought it to the notice of the court at the earlier stages.
But they
No, last time
vehemently
only-
objected.
No, not
Twice-
before this honorable court.
Okay. Twice, Mr. Chaudhary made an attempt. We got it listed, but
Yes, Lordship has given us ample opportunity.
It was long.
Lordship has given us the opportunity to make mention also for early hearing also, upgrading the matter.
Because he is only concerned with hybrid maize, my lord. But the tender, my lord, contains two clauses, hybrid as well as bio-45. And 6,25,000 is for both. And it's on 6,25,000 that the value is taken. Because I have applied for both.
no, that is easily understandable.
Lordship, then what free clause is nothing.
Now this Napier seed case is alike. Lordship. In this case also, they have the same kind of
So
objection.
this-
Lordship may hear the other case.
So this we can record your statement.
Yes,
and
yes,
then
Lordship.
it will be closed.
Yes. That's why I interrupted Lordship with due permission.
No, it's okay.
So, my lord, if state authorities are basically anticipating to close.
Because next year, the same maize will cost more because this price will not be valid next time also.
Correct. So there's an old movie, Gone with the Winds.
They are contemplating to close, cancel the tender process. But
We have, the director has spoken now with
Ah.
my assisting counsel.
Okay. I'll pass orders on this. Mr. H. Buragwai, learned counsel for the petitioner is present. Mr. D. Saikia, learned Advocate General, assisted by Mr. V. Chaudhary, learned Standing Counsel for the Agriculture Department, on receipt of instructions, has submitted that the supply of maize seeds to the farmers was for the purpose of pre-kharif,
Yes, yes.
Pre-correct.
pre-kharif supply. And the ideal sowing season
Was February
is
till
from
March.
February till
April 2023.
February to April 2023. First of all, it is submitted that he has been instructed by the
Director,
Director of Agriculture,
Agriculture.
Assam, that that as the project was a World Bank funded project. After expiry of the season, they would not be supplying the said seeds, which is therefore therefore it is submitted that the issuance of tender has lost its purpose. Full stop. Next, accordingly, as the statement is made at the bar by the learned advocate general, this representation stands closed, having been rendered infructuous. Okay. Just a moment. Mr. You can hire senior counsel, assisted by Mr. A. Barwa, counsel for the respondent number.
Newly implemented respondent number 5.
Newly implemented respondent number 5.
In
is present.
1732, 1732.
No, 760.
760.
He is present.
So we are in 1732. my lord.
You're not in
No,
760.
not 760. Same.
Then
connected
they're
matter.
not required. They're not required.
1732.
No, then you're present because it's independent orders I am passing.
Lodge.
Yes, now Mr. Buragoy.
My lord, in 1732, we have challenged a decision pertaining to the same tender process. So even in that case, my lord, that case would also become infructuous.
The rejection was,
Because
his rejection was.
my rejection on the ground that I am not technically valid
Also, same order will be
Same
here
order.
also.
either
Okay.
because
I mean,
it
717.
emanates from the 760 writ petition wherein the authorities have taken a call to cancel my
Okay.
bid, my lord, on the same ground which was under challenge.
Okay. For Mr. H. Buragoy and counsel for the petitioner. First of all, he has submitted that against the
My lord, at page 232 is the decision. 232. We have challenged here.
Sorry, my lord, I was.
No, it's okay. Two matters have become infructuous. The disqualification of the petitioner by impugn order dated 21/3/2023 on the ground that is not technically, the bid was not technically responsive. Has been challenged in this petition filed under Article 226 of the Constitution of India. Same submission of Mr. Mrs. Saithya. And then here you write, Mr. You can hire senior counsel, assisted by Sri Barwa, counsel for the private respondent number 5 is present. Okay.
Today we had filed an IA that is coming, my lord had permitted it. So that will also, in view of this order, that will also be closed.
This is IA.
Today, my lord. closed.
Okay, IA by 5. WBC 1732. Closed in view of other past instances. Yes, up to 1.5.
নিয়ে আজিও ফাইল কৰিছে তাৰপৰা নিয়ে আজিও ফাইল কৰিছে মাল লৈছে তাৰপৰা
His
Only
barrier
is
is,
benefited.
no. The barrier is good. At times I don't hear something.
I think time has come, my lord, this barrier should be lifted now.
No, it has to go.
Call now, my lord.
And especially why this barrier, my lord, we often find very difficult to go around this.
No. This was due to that
No,
COVID.
sometimes
protocol.
it is good,
Follow,
lordship.
And at that point of time, I was one of the worst sufferers, the first sufferers.
No, my lord. if
Twice
these are
I got
decayed,
infected.
then Writing something else, therefore better we.
So,
put this
sometimes
back.
with my learned senior friend on the other side, it's better. I'm protected, lordship.
Then the state will lose. Then the state will lose. Because then we'll have to give bulletproofing.
Bulletproofing or I have to wear a helmet.
No, but I
No.
think time has come.
No,
This
time has
should
come.
be-
Yesterday, in fact, I could not see Mr. Nair, and I thought I was happy. There was frosting in the glass, complete frosting of the glass. So I told Mr. Nair that I'm thankful that I couldn't see you.
Too much of moisture, even in the vehicles, lordship.
Uh-huh.
Last 3-4 days it is happening.
The specs also.
I just write a note to the court to withdraw this. Mr. Chaudhary will,
My
we'll
lord, it
follow
will
your-
be a huge wastage of expenditure, lordship. Let it be there.
There for some.
Because you never know, lordship.
COVID, let that COVID thing go finally.
no, it will not going, nothing is going. Once anything has come, it's not going.
Well, we can have this glasses removed, my lord. Let the other one remain for some time. This can be removed. The outside barrier.
I think-
So this will
I
be
think
shared
there are
wastage,
two
that's why.
layers.
It has some.
Two layers.
condition where-
Because at that point of time, it was
No, it was
deemed
necessary. Of course.
Let it be for some more time. So we don't know when that thing will again.
These are expensive affairs, lord. That's why. Let it be.
Yes, it is. I'm told it's costed more than
very
5
costly.
lakh,
These are tough and glassy, if I am not.
more than 5 lakh rupees to set this up.
And
each
when
pocket.
one it is removed, it will not be of any use.
No, it will not be of any use. It will not be of any use.
For some more days.
It will be there in for the one who
Yes,
Made with the lodge.
yes.
Now here, my lord, this is also in a tender for procurement of, seeds, no? Napier grass, my lord.
Slips.
Now, if your lordship would kindly come to page 68, my lord. This is being used as a fodder for the cattle. Now, page 68, my lord, no, sorry, page 74. That's the tender notice dated 24th of March 23. Director of Agriculture Assam invites online bid from eligible company, producer, authorized supplier for supply of Napier slips under the World Bank Finance Project so and so. Detailed IFB notice and the related documents may be downloaded from the Assam e-tender portal, so and so, so and so, so and so. Last date for submission of bid is 7th of April 23, it should be. It is information, so and so. So this is the tender, my lord. Now, page 79, my lord. The government has received financing from World Bank towards cost of agribusiness and rural transformation project, etc., etc. Now, kindly see in that box, my lord, the quantity is 3 lakhs. Oh, 3 crore 90 lakh. Yes. Now, my lord, what had happened? We are basically assailing a condition whereby, my lord, some minimal turnover has been prescribed. As in the earlier case, my lord, here also, my lord, there is no correlation. In fact, my lord, lordship knows it is a fundamental, principle rather. If you are asking for a turnover, then it must have some correlation with the total worth of the supply.
No,
Supposing,
you
my
see,
lord,
no, you see,
yes,
this is quantity is 3 crore 90 lakh
yes.
Napier slips.
So what is the value of it? So unless we know the value, my lord,
If you just ask your instructing council to open the net and find out,
yes,
each Napier slip is 2 rupees.
Ah.
And 1 kg cost is 3,100.
No, it's number, my lord. It is number only.
Slips, my lord.
It's not on kg or so. It's
No, that's what I'm saying.
Ah, ah.
It is 2 rupees per slip.
Okay, my lord.
And if you buy it in kg,
Yes.
you will find it 3,100 rupees in Amazon. I've just checked out right now.
Acha, acha, acha.
Correct. So 3 crore for 4 crore slips
Huh.
for easy calculation.
Huh.
390 into 2 is 780.
780
So 780 is the value.
value. So, my lord, normally, if we go by the CBC guideline also, the turnover should not be more than 30%. Now, here what they have prescribed is, my lord, 4 crore for the last 3 preceding years. That means, my lord, 4 into 3, 12 crore. So this is not, my lord, commensurate with the requirement. In fact, in the earlier case, my lord,
But Mr. Chaudhary, after all these judgments of Supreme Court,
yes.
which makes this
No, my
untouchable.
lord, no, my lord, whenever state introduces any criteria, my lord, be it recruitment, be it procurement, definitely state has the prerogative, my lord. Normally, court will not interfere. But if a citizen or a litigant can come up before the court and project a case where the exercise is unwarranted, then lordships will interfere and remand the matter back. I'm not saying lordship will determine what it should be. But if a lordship finds that determination is wrong, then certainly lordships can interfere, my lord. End of the day, my lord, in Tata Cellular, what was said? If there is an arbitrariness in the projection, then certainly lordships can interfere. Now, in the earlier case, my lord, we have shown by facts and figures in our affidavit, which has been supported by the, my lord, the director's affidavit, that yes, what we projected is correct. For a requirement of 1.4 crore, the 3 crore was prescribed.
Here also it is.
Here also same thing, my lord.
More happy to read that this.
Now, in the affidavit in reply, we have given that figure, my lord. If your lordship would kindly come to. This paragraph.
Sir, paragraph.
Page to page.
Page 256, sir.
My lord will kindly come to 256, my lord.
এই প্যারাগ্রাফটা অনেক দীর্ঘ হয় স্যার।
Yes.
My lord, it starts at 256, my lord. And if your lordship will kindly come to 257, the first subpara. At page 257, further the contention of the said respondent number 3 to the effect that clause of financial turnover was kept at original published turnover of 4 crore, which according to the said respondent was 35% of the bid value, and it was the least financial soundness that they could prefer, and same was basically introduced so that participating bidders with requisite financial soundness and technological know-how are chosen to provide, deliver, execute the total quantity of free so and so number of papers in the state of Assam is again denied, being wholly misplaced and misconceived by them, in as much as even by going the value of 11 crore 70 lakhs.
For the first time in affidavit,
They have said, for the work in question, the annual average turnover sought for by the input clause, which is 4 crore, is alleged 35% is only in respect of one financial year in the 3 consecutive financial year 1920, 2021, 20. Hence, there is clearly an error apparent in arriving at the calculation as aforesaid, that is 35% of the bid value, which is so and so of so and so by the respondent authorities, by taking one financial year without denying, giving any due regard to the remaining 2 financial year as envisaged under the impugned clause as introduced by the corrigenda. As per the impugned clause, it is evident that bidders are mandated to have an annual average turnover of 4 crore in the last 3 years, which means it is 12 crore for the last 3 consecutive financial year, and the said amount of 12 crore can by no stretch of imagination be taken to be 35% of the bid value of so and so.
11 crores.
In fact, the aforementioned amount of 12 crore is more than the bid tendered value of rupees so and so. In question, and respondent by projecting that only 4 crore is the requisite annual average turnover, demand by the impugned clause is nothing but an eyewash and a misrepresentation of the relevant provision, etc., etc. My lord, kindly come to their affidavit, my lord. At paragraph number, my lord, 7. Yes. If your lordship will kindly come to page 213, my lord. If your lordship would kindly come to page 214, somewhere in the middle, the sentence starting with clause for the financial turnover at page 214.
Yes.
The clause for the financial turnover was kept at the original published turnover of 4 crore, which was 35% of the bid value, which is the least financial soundness that could be preferred. The financial turnover condition in the NIT has been inserted in order to ensure that organizations with requisite financial wherewithal and technology know-how are chosen in order to deliver, execute the total quantity of 3 crore 90 lakh number of NAPER slips in the entire state of Assam. The petitioner stated that he had sent his representative in the this is not required. So this is their stand, my lord. So my lord, when you arrive at a figure, that figure must have some rational relation with the objective sought to be achieved. But if it is more than what is required, and more that too, my lord, in the originally this was not there. This was brought by an corrigenda. So my lord, things are not very, and in fact, my lord, this gentleman who did all these things, he has been, my lord, transferred now. This honorable court has virtually indicted him in a series of cases. In fact, in the earlier round of litigation. He did a lot of wrongdoings, my lord. No. Now, for example, if your lordship should kindly come to my lord, page number 98, my lord. Sorry. Of the writ petition 110, my lord.
Yes.
Page 110, my lord. The original NIT.
They were only mortar clause.
So my lord, there is a lot of, there's many questions about the bona fides. And you see, my lord, technical part, qualification criteria. The purchaser shall assess each bid against the following qualification criteria. The requirements not included in the text below shall not be used in the evaluation of the bidder's qualification to so and so. Now kindly see, bidders should be registered organization so and so. Bidder must be in the business of cultivating, etc. Must have at least one work order in last 3 years. Bidders must have existing Napier cultivation field of approved varieties specified under the bid. Bidder need not provide proof own lease land, undertake harvesting of so and so. The farm from which Napier slips will be delivered by successful bidder will be within a radius of 500 kilometers. Crop aging must be so and so. There must be minimum 85% growth. So, my lord, this turnover criteria was nowhere there. In fact, my lord, in the earlier tender, if your lordship would kindly come to page number 179, it starts. The earlier tender, my lord, it starts at 179 and the operative portion is at page 186. It was earlier, my lord, but the same department. The said clause is not there.
Page.
Page 186, my lord. It starts at 179 and at page 186 is the technical bid evaluation criteria given or the requirements are there, my lord. And you see, my lord, here also what was required was at 8IJK at page 186, audited balance sheet for 3 financial years, ITR for the last 3 years, and financial soundness certificate. There was nowhere, but department never had, my lord. They are now introducing. I'm not saying, my lord, it can't be done, but then Supreme Court says you do it afresh. You can't do it midway. Now, my lord will kindly come to page 168, which has been introduced for the present case.
That is scale group matise. Group আছে একটা গ্রুপে আপনার 3 টাকা দিব
Kindly come to page 168, my lord. Serial number 3. Qualification criteria ITB 32.1 added. Bidder should have an annual average turnover of 4 crore in the last 3 financial year. My lord, with all sense of responsibility, I am making this submission, my lord. Why corrigendums are issued? Corrigendums are issued following pre-bid meeting, my lord. If something has emerged which requires to be addressed, normally, my lord, corrigendums are issued to take care of those situations. A corrigendum is never issued to introduce a new criteria, my lord. Maybe some modification is required. Maybe, my lord, some conditions which appears to be unreasonable, which parties cannot meet. In such a situation, my lord, the power of issuing corrigendum to address some, my lord, error is done. My lord, corrigendum is never issued, to add a new criteria, which might virtually, takes away the basis of the tender, my lord. These are all matters of, my lord, common sense, my lord. On every point there may not be an authority, but at the end of the day, my lord, this has to be tested having regard to whether the action is bona fide, whether the action is, my lord, arbitrary. Now, having regard to the antecedent of this person during whose tenure all these things were done, my lord, a lot of suspicion arises. In fact, in Monarch infrastructure case, my lord, in a similar situation, Supreme Court said, you go for a fresh tender.
কি করে স্যার? 12 কোটি টাকা আৰু 11 কোটি টাকা, 11 কোটি বলছিল আৰু 12 কোটি দিছে আপনার
My lord, in Monarch's case, the Honorable Supreme Court has taken the view, in such a situation, one should go for fresh tender. Why, my lord, change the structure of the tender? Please come to para 12. At page 292, my lord. If we bear these principles in mind, the High Court is justified in setting aside the award of contract in favor of Monarch Infrastructure because it had not fulfilled the condition relating to clause 6A of the tender notice, but the same was deleted subsequent to the last date of acceptance of the tender. If that is so, argument advanced on behalf of the Monarch Infrastructure in regard to allegations of malafide of the Commissioner of the Municipal Corporation in showing special favor to Monarch or other contention raised in the High Court and reiterated before us as insignificant because the High Court has set aside the award made in favor of the Monarch. The only question therefore remaining is whether any contract should have been awarded in favor of the Monarch Infrastructure. The High Court had taken the view, if a term of the tender having been deleted after players entered in the arena, it is like changing the rule of the game after it had begun. And therefore, if government or the municipal corporation was free to alter the condition, fresh process of tender was the only alternative permission. Therefore, we find the course adopted by the High Court in the circumstances is justified because by reason of deletion of a particular condition, a wider net will be permissible and a larger participation and more attractive bids could be offered. Now here it was a case of, my lord, deletion and ours is a case of addition. So end of the day, my lord, the principle has to be same, be it deletion or addition. So let them issue, go ahead and bring out a fresh tender. And my lord, this prescription of 4 crore, that has to bear some rationale with the, my lord, objects ought to be achieved.
And the value of the work, sir.
And the value of the work.
They are seeking more than the value of the work.
My lord, if the value of the work is something,
11 crores, sir. Yeah.
now, my lord, that's supposing for a work of construction of work, say, my lord, 1 crore. The turnover which can be asked for is 30 lakhs or maybe 35 lakhs. How can, my lord, for a work of 1 crore, in the last preceding 2 years, my lord, it could be something like, my lord, 2 crore or something. My lord, we as a citizen, we can always say that the action suffers from the vice of irrationality. It's a irrational, my lord. We appreciate, my lord, the contours within which your lordships exercise the power. It is confined to the decision-making process. Now, all that we are saying is, my lord, this does not have any relation with the objects sought to be achieved. If that be so, my lord, then certainly, my lord, it's a ground for intervention, my lord. Let them issue a fresh tender, let them insist on turnover, but it must be a reasonable one, which is permissible according to the CVC circular. I think, my lord, in this case, we can always take CVC circular as the, my lord, Bible.
No, unless it's shown that the state government has adopted it, it's very difficult to accept that.
Even otherwise, my lord, let them adopt a very rational approach, my lord. That's my only submission.
And the procurement rule emphasizes on maximum participation of bidders. This will hamper the participation.
And my lord, the Assam government has recently come up with a statute. That is, my lord, Assam Procurement Act and the rules. And in the rules, my lord, if your lordship would kindly have these rules. If your lordship would kindly come to page number 1589, my lord. 1589. Roman 5.
Yes.
A procuring entity shall invite bids in open competitive bidding and two-stage bidding or pre-qualification or registration of bidders by issuing notice inviting bid to be published in the state procurement portal. In case of open competitive bidding and two-stage bidding with value below the mandatory e-procurement threshold, if NIB is not published on SPPP, an abridged notice shall be published in newspaper of wide and adequate circulation wherein address where details and bidding documents shall be made available must be mentioned. An invitation to bid published on the state public procurement portal shall contain at least the following information. Maximum.
Somebody issued a large liquid offer. Yeah, open competitive bidding.
Where is, no, where is publicity? 1 second, my lord. Like a silo. 1 second. One second, my lord. One copy to your court of duty. Very good. Act, my lord, not in the rules, yes. Section 4, my lord. Please come to section 4, my lord.
Yes.
In relation to public procurement, the procuring entities shall have the responsibility and accountability to ensure, please come to B. Transparency, including consistency, objectivity, predictability, openness, fairness, equality in relation with the bidders. So end of the day, my lord, the clause which will be insisting upon, it must be objective, my lord. And objectivity, we all know, my lord, it must stand to some rationale. So, my lord, when you are insisting, first you are not introducing initially, by way of an corrigendum you are bringing it. And secondly, the amount which you are insisting, it has got no relation with the object sought to be achieved. Therefore, merely because, my lord, as a tendering authority, you have the discretion. But then, my lord, in the public administrative law, my lord, there is nothing like unfettered discretion. Discretion always implies, my lord, and duty to act fairly, having regard to the, my lord, principles of equality. So that being the position, my lord, I'll respectfully submit, my lord. First, the insertion of the clause by FN corrigendum is perhaps not in very good taste, my lord. And secondly, the amount is, my lord, unreasonable. Therefore, lordships will remand the matter to the authority. They could insist. We are not saying, my lord.
Just, please come to page 79.
Yes, my lord.
This
Yes, my lord.
last A, B, C. A is price of bidding document.
Last date of sale.
No, the B, date of commencement of sale is 27th.
Yes, my lord.
And this corrigendum has come on 30 March 2023,
Yes.
which is way before last date of sale of bidding document.
True.
And the bidding will start on the pre-bid
No,
meet
last
is,
date was 27th.
no. Next page 80, pre-bid meet is 10/4/2023.
10
Therefore, even this corrigendum, everybody had adequate chance to understand what this is about. How do you suffer a prejudice?
No, my lord, I'm not on that. What I'm trying to, satisfy your lordships is, my lord, that insistence of 4 crore, is it, my lord, germane? That is the point.
The value is 11 crores.
You see, as a R.K. Lakshman's common man, you see, why
7.8 crore.
তাহাঁতি valuation কৈছে 11 কোটি টকা 20 value
you see,
12 কোটি টকা আমাক বিচাৰিছে স্যার
you see, as a common man, R.K. Lakshman's common man, you see, what I find in Amazon is 2 rupees per
So 7.8 crore.
7.8 crore, which somebody who is tendering gets at what you call the
Now, for that, I'm supposed
12
to
crore.
show 12 crore.
No, that's okay, but it's 12 crores. So therefore, as a common man, if I think it's a 5 crore net profit, correct. But there's a rationale in it. It's not just for nothing they are doing it, because now they are wanting that this, insofar as when I've read these conditions, when I read alone, I don't know whether I'm reading it right or wrong. What I understand is that they will have to cultivate within the 500 meter area of delivery, and then they will give it. So therefore, number one, they are promoting an industry, allowing people to earn out of it, and then make a supply, and then again earn a profit out of it. So they are encouraging a sort of plantation in the state of Assam. So therefore, they have their own reasons to justify what can
My
be.
lord, we are not on that. What I'm saying is, my lord, for executing a work of, my lord, 7.8 crore, do you require, my lord, 12 crore as a, my lord, turnover?
No, you see,
That's the
what
point.
is
Nothing.
what is the supply time?
3 days only 3 days.
3 days.
3 days. So you have to be cash rich to make
My
that
lord.
delivery. You have to be cash rich.
No, I don't have to have cash double the amount is required, my lord. So my lord, end of the day, this will retard competition. No, my lord will kindly see section 4 says, any condition you impose, it must be objective. So what is the objectivity we can derive from this imposition, my lord? That is my submission. My lord,
Yes.
for a moment, we are not saying, my lord, what government is doing is wrong. Maybe they had a bona fide intentions, but in spite of having bona fide intentions, my lord, sometimes, my lord, decision-making process may go wrong. And for that, my lord, the 226 court is there to take care. Of course, you will have to accept our contents.
Okay.
That is my simple submission, my lord. There is no objectivity in prescribing a turnover of 4 crore when the whole work is, my lord, of 7.8 crore. So if we go by CBC circular, my lord, I think, 2 crore or even 2 crore would have sufficed, my lord. Because it's not that you must, idea is to, my lord, you must be financially sound. All along, they were judging the financial soundness by, my lord, income tax return and financial soundness certificate. Normally, my lord, as a businessman, we all know, my lord, if I have got very good rapport with the bank, by paying 10 lakhs, I can have a bank guarantee of 15 lakhs also, depending upon the, reputation which that customer has in bank. So end of the day, my lord, on mere cash, a business doesn't, follow, my lord. That being the position, my limited submission is, my lord, whether the action is rational. If your lordship considers it is rational, it's well and good. Otherwise, my lord, I will respectfully submit. Let them remand the matter. Let them issue a fresh NIT, my lord, wherein they may like to insist on the clause from the very beginning, but having regard to the, my lord, amount of the contract, they will fix it. That is my humble submission, my lord. Lordship's kind permission.
Basically, I have to address lordship on the point of insertion of the clause of turnover. In fact, before publishing the final tender documents, lordship, the notice inviting tender, a draft was sent to the authorities under the World Bank, lordship, and they have approved it. In that also, the clause was there. Somehow, at the time of publication, lordship, that clause was somehow inadvertently dropped out. So immediately it has come to our knowledge and we have rectified and by issuing a.
No, that was a question I posed on the last
Yes,
occasion.
in
Was
our
it better?
affidavit also, and I have all the documents. We have annexed the documents here.
Okay, just show me that first.
Yes. Lordship will kindly come to paragraph 4, then I'll show the documents.
Because yesterday,
Yes.
that is the first question,
Yes, yes, Lordship.
last time when it came. This is the
In
first
our
question.
affidavit, that is the main thrust, lordship.
Just show me that
Yeah.
first.
Paragraph 4, I'll write 4 lines, then I'll go to the documents.
Uh-huh. That is
209.
209.
Paragraph 4. As regard to the statements made in paragraph 2 of the report, the petitioner has claimed that he is in the business of supply seeds, including Napier, to the department, and petitioner is otherwise fully eligible and competent to participate in. However, in this particular tender, the petitioner has failed to demonstrate his eligibility. The petitioner could not meet the financial turnover. Moreover, as stated and submitted by the petitioner, the bid conditions were not restrictive, especially the turnover, which is 35% of the entire bid amount contract. The turnover clause was initially proposed by respondent number 3 by submission of draft bid document for approval to State Project Director in short SPD, Area Society for Procurement of Napier Seeds, by later dated 16/3. Lordship will kindly mark this date 16/3. The draft bid already had the point under page 35 technical bid qualification IFB 0.32.1.4, which reads that bidder should have an annual turnover of 4 crores in the last 3 financial years, 1920, 2021, 21-22. The bid document, the draft bid document had been approved by SPD areas by later dated 22/3/2023, and it was published on 24th actually, with some changes. Point 4 relating to annual turnover, annual average turnover required of 4 crores in the last 3 financial bid was not changed and was accepted by SPD Areas Society. However, due to an unintentional error on the part of the Directorate of Agriculture, the said clause was erroneously not included in the final tender dated 24/3. That means 2 days later. And since the same was already approved prior to the bid uploading date, the condition for turnover was included by corrigendum dated 30/3/2023. Last date was 27, Lordship has already indicated, 27/4. This implies that the clause of average turnover requirement of 4 crores in the last 3 financial year was proposed and approved prior to the bid date, that is 24 March 2023. But was erroneously inadvertently not included in the bid document published on the mentioned date. The said corrigendum was issued in terms of the power authority given to the purchaser. This is contrary to the prayer made by the petitioner that the said clause provision was introduced in the middle of tender process for the first time without assigning any cogent reason. Now coming to the amendment. We have the annexers here. Page 225, Lordship, Annexer A.
Just a moment. Yes, page.
Page 225, Annexer A of that affidavit in opposition. It has gone from the Director of Agriculture to the State Project Director, Arias Society. Procurement of Napier slips, etc. With reference to the subject cited above, I have the honor to state that this office is going to for procurement of Napier seeds under the Assam Fodder Mission. In this regard, a bidding document is drafted and enclosed with the letter. The bidding document may be perused and approved by PCU Areas Society with necessary comments input, if any, for taking up further procurement process. There is an email also to that effect on 17 March, Lordship. Next page. That email consists of the forwarding letter, which I have just read, and the documents. Now, page 227 is a draft document. RFB request for bidding. Date of reference so and so. These are the tentative. We have not included the date here. This was the draft. Then
You're
Lordship,
reading where?
I'm reading page 227. I have already placed 225 and 226.
Yes.
Then 227 is a draft document which was sent to the Arias State Project Director, SPD, for his vetting. So it starts from national bidding document for supply of Napier slips, Kharif season. Next page, Lordship, 228. Clause qualification, technical part, qualification 32, 1.1 qualification criteria. Then Lordship will kindly come to 4. Bidder should have an annual average turnover of 4 crores in the last 3 financial years, that is 19-20, 20 and 21-22. So this clause was there in the draft. It was sent and they have responded by their letter dated 22nd of March to page 229. Written by the State Project Director to the Director of Veterinary Agriculture Department. Subject approval of bid document for Napier seeds. In reference to the letter cited above, which I have referred to 16th March, this is to inform you that the draft bid document for procurement of Napier slips under Assam Fodder Mission submitted by OPPO Agri is hereby approved subject to the following changes. Evaluation and qualification criteria, they have suggested some changes, not on the technical thing. You are requested to proceed with procurement process. Next page, Lordship. The email also we have received from them. Then on 24th March, page 231, we have issued the document. And page 32 is the index NIT, the national bidding document. Here, Lordship, we have put the dates now. In the first draft, we did not put the dates, only the month was there. Now, date of commencement of the sale of bidding documents 27/3, last date of sale of document for bidding document 27/4, Last date and time for receipt of bids 27/4 at 3:30 PM. Date and time of opening of the bids 27 at 4 PM. Officer inviting bids, Director of Agriculture, Assam. Page 220, 233. If Lordship is pleased to come to the same technical part, serial number 4. In the earlier, in the draft, the turnover was mentioned. Here that is not there. So in the public domain, Lordship, this has gone, and where this turnover clause is totally missing. And once we realize it, Lordship, in all tenders there are turnovers to check the financial soundness of the parties. Page 235. Within 3 days, because the sale commenced on 27th March. On 30th March, within 3 days, we issued this corrigendum. Lordship will kindly come to page 235, serial number 3. Qualification criteria, ITB 32.1, point number 10. 9.20, point number 10 added. Original provision added. And bidder should have an annual average turnover of 4 crores in the last 3 financial years. 1920, 2021, 21, 22. So this whole clause is added here. There is no modification as such of the clause, but we have inserted the whole clause, which went missing on the tender documents issued on 27th.
Yes.
Now, this is a World Bank project, Lordship. Lordship will kindly come to Now, regarding the authority of the employer or the purchaser. If Lordship is pleased to come to page 79 of the writ petition.
Yes.
Number 1, serial number, the same tender document I am placing.
Just want to take a break and come back.
Lordship.
Just give me 2 minutes.
Lordship. Because the clause was deleted at the last hour, that is what it is written there. My learned senior friend was pleased to read it. Page 12, paragraph 12 of the
That
judgment.
is subsequent. Subsequent.
Yes, Lordship.
Subsequent to last date of acceptance.
Last date of acceptance, yes.
I've read it. That-
Yes, Lordship. So that situation is not, this cannot be put into our situation. Therefore, this judgment will not cover our case. Now, regarding the amount, because they say that amount is arbitrary, exorbitant, whatever word they have used, Lordship, that it is much more and it should not have been fixed at 4 crores. And they are also saying that the value of the tender is more than the turnover value. In my humble submission, it is not like that. The period of supply is for 3 days. That within 3 days, the supply has to be made. That means they should be catch risk. Number 1. That 12 crores which they have calculated, that is for a period of 3 years. That means every year 4 crores, 4 crores, 4 crores. If the supply period was for 3 years, then that argument would have some meaning. So that argument of 12 crores, which is more than the bid value of 11 crores 70 lakhs. That will not cover our situation, because in our situation, that supply of about 12 crores is to be done within 3 days of the issuance of the supply order. So whatever is done, whether it is 33% or 35%, there is no such clause. Whatever clause is there is that we should be reasonably satisfied that they have the financial capacity, financial soundness to do the work at the point of time when it is required to be done. If they delay it by supplying it within a period of 1 year, Lordship, the whole purpose will be lost. I have just considered one case that by April we could not do it, so the whole thing is now become still. It has no meaning now. The maize seed will not be effective for any purpose. Identically here also, when the order is given, why this 3 days period? Because the plant should be, the seed should be put into the ground. It should be fitted, na? It should be
Sown.
sowed immediately, Lordship. So it cannot delay. So in that submission, that whether the amount is reasonable or unreasonable, Lordship, the purchaser, Lordship, after application of mine has inserted that about 33 to 35% is reasonable. And by that, we are not violating any norms anywhere. First is that whether turnover clause should be there. Turnover clause should be there like in any other tender document, any other tender process. And in the other case also, now they are also accepting that it should come down. That means turnover clause should be there. So while we have inserted turnover clause, Lordship, it was not that something alien we have incorporated. Somehow due to inadvertence, Lordship, maybe it is a devil's praise devil or whatever, Lordship, that in the praise also it could have been dropped, or I do not know what may be the reason exactly. But whenever it has come to our knowledge that turnover clause is missing in the tender document, prompt action was taken. And it was done in a very transparent manner by giving reasonable opportunity, reasonable time for everyone to comply with that particular clause of turnover. If they fulfill the clause of turnover by the corrigendum of 30th April, March, Lordship, even if at the first itself, if it was issued on 27th March, then also they would have fallen into the same problem, because they do not have the requisite turnover of 4 crores annually for last previous 3 years. So they do not fulfill the criteria. Now that criteria to make it unreasonable, Lordship, they have not submitted any more evidence to show that this is an arbitrary action on the part of the authorities to give a particular figure. Although in their reply, they have done certain things, which according to them is that the total value is 12 crores. So, and therefore, if we consider 4 crores each year, then the turnover is also 12 crores. It is not like that, Lordship. What we are saying is that average turnover, the word average is there, average annual turnover. That means in 1 year, it should be 4 crores.
Tell me that again, is it average? I did not.
Yes, average.
Okay.
Corrigendum, Lordship.
168.
Yes. Page 168. In the writ petition also it is there. In my affidavit also it is
Yes,
there.
yes. Average is there. Yes.
Average is there,
Okay.
not aggregate. Had it been aggregate, the things would have been different. So average annual turnover. And this is very logical, Lordship, because in 3 days' time, they have to spend 11.70. Let us there be a profit of 30% or 20%. Then also they must have an amount of 9 crores plus with them. So when we say that 9 crores should be ready for them to do the supply, 4 crores is very meager, less than half, by considering the profit component also. So very reasonable, Lordship, by all means. Then their prayer for fresh tender, Lordship, that will not be permissible in my humble submission, because the process has already there and there is no reasons to recall this tender process and go for a fresh one. Because suppose, according to them, Lordship, that turnover clause was inserted on 38th of March. We could have cancelled it on 29th and issued a fresh tender. What difference is there? Practically and effectively, there is no difference. Whether that corrigendum was issued on 30th or on 27 itself, we have issued the tender notice with the clause of turnover inserted therein. So effectively, there is no difference. Within 2 days, if we see on which that they have procured the tender document, it may be after 30th also. I'm not sure about that, but guessing, Lordship. So whoever has procured the tender document on 1st, our clause 8 says that any addendum or any corrigendum will be a part of the tender document. So that will not make any difference from any perspective. Then they are also saying that it should be transparent by taking course of that 2017 and 2020 Assam Procurement Act, Lordship. So whatever we are doing, it is very transparent. There is no hide and seek game here. Whatever is there, it is in the public domain. We have issued the corrigendum, it is in the public domain. Nobody can say that they have not received that document. And the action, whatever we have done, the draft also we have disclosed before this honorable court. The approval granted by the state project director is before this honorable court. And this is a World Bank's project, Lordship. There cannot be any hide and seek game. Then another submission was that arbitrariness. So I do not understand from what point of view it is arbitrary. Fixing the turnover at 4 crores is arbitrary, or inserting the clause in the tender document. The clause of turnover in the tender document is arbitrary, Lordship. In my humble submission, none of this argument will stand. They do not have any cogent reason to say that there is arbitrary action on the part of the Agriculture Department, or to that effect the areas which have approved the draft bid document, Lordship. They have done any arbitrary action in this. So whatever clauses we have given, it is for general and it is a part of the national bidding document. It is not for any particular blue-white person of our area or any of officer's favorite person to have done all these things. Whatever is there, it is in the national domain. Whoever qualifies, they will have to do. Whoever do not qualify, they are out of the game. And we are very pinpointed that within 3 days of issuance of the supply order, they have to supply. And there is a scientific reason for this also. These Napier slips will not survive beyond a certain period of time, very less time. That is why that area of where it has to be cultivated, from where it has to be procured, all these nitty-gritties are there in the NIT. So in support of my case, Lordship, I would like to place 2 or 3 judgments, which Lordship is already well aware of. Turnover judgment. UFlex versus State of Tamil Nadu. 2022 1 SCC page 165.
Yes.
My Lord Justice KK Kaul and my Lord Justice H. Roy. Just 3 paragraphs, Lordship, 42, 43, and 47. So I would like to just place paragraph 47, 2 lines.
Yes.
Insofar as the participating entities are concerned, it cannot be contended that all and sundry should be permitted to participate in matters of this nature. In fact, in every tender, there are certain qualifying parameters, whether be it technology or turnover. So turnover is a requisite criteria to select the bidders. One is technology, the other one is The court cannot sit over in judgment on what should be the turnover required for an equity entity to participate. The prohibition arising from only a limited company being permitted to participate was again addressed by the corrigendum permitting LLP to participate. If entities like Kumbhat and Alpha want to participate, they must take necessary actions. Alpha is already an LLP. Kumbhat cannot insist that it will continue to be a partnership alone, and thus partnerships must necessarily be allowed to participate. So here they do not have fulfilled the criteria of turnover, lordship. They are out of the race, lordship. These are commercial activities, and in commercial activities, equity, welfare, all these things are kept at bay. So it is very clear. In fact, in every tender, there are certain qualifying parameters, whether be it technology or turnover. But can be other criteria also. But turnover and technology are very much essential. Agmatel India Private Limited versus Resources Telecom. Uh, 2022 5 SCC page 362.
Yes,
Paragraph 26. There are several paragraphs, but this is only relevant.
26.
Paragraph 26. The aforementioned statements of law made it amply clear that the author of the tender documents is taken to be the best person to understand and appreciate its requirement. And if its interpretation is manifestly in consonance with the language of the tender document or subserving the purchase of tender, the court would prefer to keep restraint. Further to that, the technical evaluation or comparison by the court is impermissible, and even if the interpretation given by the tender document by the persons inviting offers is not as such acceptable to the constitutional court, that by itself would not be a reason for interfering with the interpretation given. What I am stressing is the first line only, that the law is amply clear that the author of the tender document is taken to be the best person to understand and appreciates its requirement. So our requirement is the turnover, lordship. So when we have said that turnover is needed, lordship, it cannot be said that turnover cannot be needed, required. Then there are series of judgments right from Central Coalfields to Silpi Constructions. Lordship, basically the same standard principles. Only one I would like to add, lordship, that in case of tender process where the involvement of World Bank is there, lordship, then there are more restrictions on the part of the honorable courts to interfere. That judgment of one paragraph in that bullet train case, lordship. That's why I produced that IFB, lordship. It's a World Bank project. 2022 6 SCC page 401. 2022 6 SCC page 401. National High Speed Rail Corporation Limited versus Monte Carlo Limited and another.
That was, I think, Jika.
Yes.
That
Yes.
was Jika.
Yes. Paragraph 37. Ours is a foreign funded project, lordship.
That's okay.
Paragraph 37. May I read it, lordship?
Yes.
The scope of judicial review in such foreign funded contracts should be far much less than the ordinary government funded contracts funded from Consolidated Fund of India. The scope of judicial review in such foreign funded contracts projects would be restricted and minimal. in such foreign funded contracts, the only ground for judicial review ought to be on a limited aspect, that is, the action of the executing authority does not suffer from favoritism or nepotism, and based on the grounds which have been concealed from the foreign financing authority, if disclosed, would have persuaded the financing authority to cancel the contract. So very limited scope, according to this Honorable Supreme Court judgment, is that when there are instances of favoritism or nepotism, that is one aspect. And the other thing, that when the state authorities or the national authorities, by hiding certain facts from the financing authority, that means the World Bank. In those situations, the Honorable Court would like to interfere. Now, this parameter or the criteria of turnover, if the government have done it, that there should not be any turnover. Somebody comes before this Honorable Court that this very important criteria has been removed by the state authorities, by the Director of Agriculture Department. In that case, Lordship would have interfered, because the authority areas is directly related with World Bank. They are having an agency through this authority, where the state project director was entrusted to look into all World Bank funded projects executed by the state government. And therefore, that is precisely the reason why that draft tender document was sent to them and not to the Secretary or Principal Secretary of Government of Assam in its Agriculture Department. So in that situation, Lordship, in my humble submission, we have not faltered in any manner. By mistake, turnover clause was missing from the original tender documents. We have immediately rectified our mistake. In that view of the matter, Lordship, there is absolutely no merit in the writ petition, and same is liable to be dismissed. This is my humble submission.
May I take some indulgence of your Lordship to allow me to respond to some of the important points my learned senior counsel had just mentioned. Well, the first point which my learned senior has mentioned is in relation to whether this was an inadvertent error or it was a part of the scheme to have erroneously left out to put. These are matter within their purview, and we are not contesting on that. But a very important aspect, if we even assume for a while that this clause was there in the tender papers, even going by their submissions, assuming that this clause was there, may kindly come to the act, my lord. Now, they cannot deny one thing, that they are one of the procuring entities under the act. That is the act which we have just submitted, my lord. That is Assam Public Procurement Act 2003, my lord. Now, this act came with certain objectives, my lord. The objectives I would like to read, my lord. What does the act say, my lord? In the first, my lord, objective of the act, if I may read, my lord, at page number 1024, an act to establish legal foundation for procedure for procurement by public entities so as to ensure timely delivery of intended outcomes with efficiency, economy, integrity, and accountability, transparency, fair and equitable treatment to bidders. My lord, this is very important. Equitable treatment to bidders, public confidence regarding good governance in the process and matters connected therewith or incidental thereto. The preamble reads, my lord, whereas it is expedient to establish legal foundations for the procedure for procurement by means of public entity to ensure the second point I would read, like on again put a lot of emphasis, my lord, the highest standard of transparency, fairness, equality towards bidders, my lord. My lord, this two particular clause, equality towards bidders and, my lord, equal treatment of bidders, are nothing but these are the offshoots of Article 14, my lord, with all my humble submission, my lord. If it be a case that an equal treatment has been given to the bidders, my lord, how is it that this arbitrary clause gives an equal treatment to the prospective bidders, my lord? Because what my submission is, my lord, is that if the emphasis is on competition, maximum participation, equality to bidders, then this criteria, the very basic nature of this criteria is arbitrary, my lord. Yes, we are not
I'll just ask you a question.
Yes, my lord.
It may be inappropriate,
Yes, my lord.
but nevertheless, that is the question.
Yes, my lord.
You see, just like me, a gentleman opens up the net and finds out that the price of the product is 2 rupees,
Yes, my lord.
correct? And he knows that Amazon will give it to him.
Yes, my lord.
And therefore this pan shop which is operating down below, selling Tamul,
My lord.
he says that, well, I will do that business. Supply of 7 crore 90 lakh, what do you call this
Birla.
Napier gas.
Yes, my lord.
I'll supply because Amazon says 2 rupees, it will deliver.
Yes, my lord.
And he has faith on Amazon, they will deliver,
My lord.
correct? So now he enters into the bidding arena,
Yes, my lord. My lord.
correct?
Yes, my lord. I've
No,
got it.
no finance required, no cash on delivery. He goes to the,
Amazon.
what you call, no, this, the
Sorry,
state government.
State government.
Says that, yes, this is the police, give me cash. He gives it to the Amazon and then end of the matter.
Yes, my lord.
Now, is it something which can be envisaged that without any criteria, anybody and everybody can become a
Bidder.
supplier?
Supply, correct. Yes, ma'am. This is a very pertinent point, my lord. In fact, this point, my lord, which your lordship has correctly mentioned, also, my lord, relates to another very fundamental point that these criteria, if we see, we are not saying that it should be completely wiped out, which my learned senior friend has just submitted before I submit, my lord, that let it be there, my lord. But it has to be it has to be reasonable. It has to be in consonance with Article 14, my lord, and the act what it envisages, my
No,
lord.
but why? If it is COD based business,
No, my lord, the question here is little, my lord, in a different way, if I may submit, my lord, if I have to rephrase it, that the clause that has been inserted in page 168 talks about 4 crores in the last 3 financial years, average annual turnover. So in the very beginning, my lord, I made a submission before lordship that what is average annual turnover, my lord? If I need to understand average annual turnover in a financial year, you need to have a turnover to a certain limit, my lord. That is assuming 4 crores, my lord. Now they are seeking 4 crore, again for another year 4 crore, and another year 4 crore, which my learned senior submits that it is not aggregate. I'm not on aggregate, my lord. But if we calculate the 4 crores in 3 years, I need to have minimum, that is, for instance, example, my lord, 1 year 3 crore, another
no,
year
we
5
come down
crore,
to we come down to a very simple example.
my lord.
You see, in order to make yourself eligible to apply for a senior council,
My lord.
the requirement is, for example, let us say that 3 years annual turnover you show us.
Yes, my lord.
Now, the question is that there can be a possibility that, well, this year I meet the criteria.
Yes, my lord.
2 years back, I may not have that criteria.
Exactly.
So therefore, whether this clause is an exclusion clause, let us say one raises the issue.
Yes, sir. There also respectfully, I would submit, my lord. Then, in that regard, my lord, the authority ought to have sought for my IT returns, audited IT returns, my balance sheet, etc. for these periods. For the reason being, my lord, having a turnover is a mandatory clause. I will have to have in this and within these parameters. I cannot go out without that, because of which in the earlier tender processes, they have sought for audited balance sheet. They have sought for 3 years financial, my lord, I mean to say the IT returns for 3 years. So the value of the work today, that is before your lordship to see, my lord, is 11 crore and some odd, according to the affidavit. Now for 11 crore work, it is easy to say that it is just 4 crore, but 4 crore is not what they are seeking. They are seeking for the 3 years, that is 12 crores, my lord, in my respectful submission, my lord. So for a value of 11 crore, my lord, you are seeking 12 crore by no stretch of imagination that can be reasonable. Had it been, my lord, 1 crore, 1 crore, 1 crore for each year, then 3 crore, then maybe, my lord, 11 crore value of the work, 3 crore in total they are seeking, it is understood, my lord. But where will a self-help group, my lord, there is a, my lord, interesting provision also in the my lord advertisement. They are seeking, my lord, inviting, my lord, from even self-help groups also. Kindly lordship may come to the, my lord, the corrigendum, my lord. Corrigendum 168, the first line, if I may read, my lord, amendment brings about certain self-help groups also. The bidder should be a registered organization, self-help group, federations, individual authorities, supplied, engage in cultivation, supply for Napier slips, Napier grass. How a self-help group can have a turnover if they are seeking, they cannot even participate in this tender process. With in my humble understanding. So let them come with a reasonable amount, my lord, which they are at the liberty to do, my lord, and let us have a competition which is open to all, my lord. Now, in this regard, my lord, they are emphasizing on World Bank guideline. I could have the occasion to peruse the World Bank guidelines relating to, my lord, what should be the guidelines or the norms of the national competitive, I mean to say, my lord, the borrowers in this kind of situation, because there are borrowers like our country, my lord, which has borrowed money. So what should be the criteria? I'll just read one line. But this is the latest guideline of World Bank regarding procurement and regulations. At clause number 5.2.5.26, my lord. These are the broad guidelines, my lord, which they need to follow, my lord. If I may read, my lord.
Best of all.
Yes, my lord. My lord, 5.26 at page number 19, my lord. It reads, my lord, standard and
Just one.
yes, my lord.
Yes.
My lord, the national procurement procedure starts from page 15, which is applicable to all the my lord, countries which borrows money from World Bank. While the first 5.3, I would just read, my lord, which is although not relevant. When approaching national market, that is us, as agreed in the procurement plan, country's own procurement procedure may be used. That is our procedure will go. These procurement procedures shall be consistent with bank's core procurement principle and ensure that bank's anti-corruption guidelines and sanction framework, etc., contractual remedies set out in its legal will
You
apply.
are reading where?
My lord, page 15, 1.5.
1.5. Okay. Yes.
May I read, my lord? So clause 5.3 says, my lord, when approaching national market, as agreed in the procurement plan, the country's own procurement procedure may be used. Meaning thereby our act or the rules that is applicable will be applied. These procurement procedures shall be inconsistent with the bank's core procurement principles. Now I will skip the other part, 5.4. For national open competitive procurement, the following requirements apply. Open advertising of the procurement opportunities at national level. Procurement is open to eligible firms from any country, that is if there is international procurement, my lord. So these are the A to I. I will skip that part, my lord. I will not. Then, my lord, the most important part, I will take your lordship to page 19, my lord, which talks about the standards and the technical qualifications that they are meant to incorporate in their national policies, my lord. 5.26 is relevant, my lord. Standards and technical qualification in applicable procurement document shall promote broadest possible competition while ensuring performance or other requirement for procurement, my lord. I'll pause it here for a while, my lord. So the World Bank also never, my lord, it says that you should curtail the competition. The basic idea is, my lord, you first introduce a tender process wherein maximum number of participation can be incorporated, maximum numbers of participation can be there, my lord. But this is in this particular provision, they are saying that they are following this provision and they are saying that this has been in consonance with these provisions of the World Bank. But World Bank never says anything regarding that you fix some criteria which will prohibit competition, my lord. also documented for emissions by definition was until 2020 up to 1 crore. It এতিয়া হে কৰিছে 5 crore, but 1 crore যদি emission definition হয় সিহঁতে কেনেকে parts আৰু এৰিয়া আছে কি কৈছে এৰিয়া আছে কৈছে এমিশন সাপোর্ট কৰিবৰ কাৰণে এই জয়েন্ট ভেঞ্চাৰ গভৰ্ণমেণ্ট এৰিয়াৰ ডকুমেণ্ট টেন্ডাৰ কেপাচিটি আছে নে নাই কাৰণ মই যেতিয়া টেন্ডাৰ এপ্লাই কৰিছো মই ফাৰ্ষ্ট ৱৰ্কটো দেখাই আছো যে ৱেইট কৰিছো এইটো প্ৰুফ কৰে যে আই হেভ দ্য কেপাবিলিটি টু টেক দিছ ৱৰ্ক Of late, recently, my lord, numbers of MSMEs has been given lot of boosting by the government, my lord, to take part in these kind of competition, my lord, bidding exercise, my lord. So these MSMEs, even in order to participate, they need to have a turnover, which according to area society, is should be around 1 crore. Because from the government of India, from MSME definition is 1 crore. So MSME definition is says, my lord, 1 crore minimum, they should have a turnover, my lord. To be defined as MSME, my lord. Now, this is just an example I'm giving, my lord. So my humble submission is, my lord, that we are not against the action of the state to completely remove this particular clause. Let it be there. Let them exercise their mind judiciously, my lord, and in a reasonable manner, let them come out with a, my lord, turnover, which will allow, my lord, maximum participation in tune with the act, my lord, in tune with the Procurement Act, my lord, and in tune with the so-called, my lord, World Bank procurement guidelines, my lord. But we do not know whether we will be qualifying in the tender process or not. I may not have other qualifications also, my lord. But let me at least participate in the tender process, my lord. At the very entrance of this, my lord, the bidding process, I have been discarded, my lord. My lord, that is my humble submission, my lord. And so far as my judgments are concerned, my lord, there also, my lord, limited scope is there before this honorable court. Of course, we know, my lord. But only in respect to Article 14, the decision will have to be in consonance with Article 14, my lord. It cannot be arbitrary, and that is what my learned senior counsel have also submitted, my lord. So on this count, my lord, I'm deeply obliged, my lord, for the indulgence given, my lord.
But Mr. K. Chaudhary, learned senior counsel, assisted by Mr. H. Buragoyan, and counsel for the petitioner, as well as Mr. D. Saikal, and Advocate General, assisted by Mr. V. Chaudhary, learned standing counsel for the respondents. Next paper. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has prayed for setting aside in question of point number 10 included by corrigendum dated 33/2023 under section Roman 3, clause 1.1 of the invitation for bids within bracket IFB for short. Hearing number. So this we will copy from page 79. Issued by the Director of Agriculture, Assam, within bracket respond number 3. As well as corrigendum dated 33/2023, hearing number This number you will find from page 168, dated 33/2023. First off, the petition is also seeking a direction on the Director of Agriculture of Assam, within bracket respond number 3, to formulate a new provision of the scheme for reducing the annual average turnover from rupees 4.00 crore as inserted in the corrigendum dated 33/2023 to a reasonable amount. Next paragraph. In brief, the case of the petitioner is that it is a sole proprietorship concern of Jyotiban, Jyotiban Saikia, and is authorized supplier of the contractor of the government of Assam, of the Agriculture Department, government of Assam. Full stop. It is projected that the petitioner has been supplying seeds to the Agriculture Department and having experience in the said field. Full stop. The respondent number 3 issued a tender process by inviting eligible bidders to supply Napier, NAPIER, slips, SLIPS. Full stop. The date of commencement of sale of the bidding document was on 27/3/2023 from 2 p.m. onwards. Semicolon. Last date of sale of bidding document was 27/4/2023 at 3:30 p.m. Semicolon. Last date and time of receipt of bids was 27/4/2023 at 3:30 p.m. Semicolon. Time and date of opening of bids with the bracket technical part was 27/4/2023 at 4 p.m. Semicolon. Date and time of pre-bid meeting was 10/4/2023 at 3:30 p.m. Full stop. It is projected that in the bid document, there was no clause prescribing qualification criteria that the bidder should have an annual average turnover of rupees 4.00 crore in the last 3 financial years, i.e. 2019-20, 2020-21, and 2021-2022. However, the same got incorporated by way of a corrigendum dated 30/3/2023. Full stop. Next, the Learned Senior Counsel for the petitioner has submitted that the price of Napier slips. Sorry, estimated. What is it called? Estimated amount.
My lord, the contract value, the work value estimated amount of the work in question.
The estimated amount of the work in question was not provided in the national bidding process. But the average annual turnover criteria of rupees 4.00 crore was provided for last 3 financial years, which is highly exorbitant and would make the petitioner ineligible to participate. It is submitted that the turnover criteria was not introduced in the previous tendering process. For a different item. It is also submitted that it is unheard of that new criteria is introduced by way of a corrigendum, whereas the appropriate procedure would have been to cancel the tender process and to issue a fresh tender for the same work. It is also submitted that for the purpose of supplying Napier slips, the respondent authorities, specifically the respondent number 3, ought to have kept the turnover criteria at a reasonable figure so as to invite more competitions. Hence, it is submitted that there is no relation of the turnover criteria with the purpose sought to be achieved, and that there was no objectivity in having a turnover clause. That's why it is also submitted that as per the policy document of the World Bank on procurement regulations for IPF borrowers, it was projected that the National Open Competitive Procurement should be structured to invite more participation by the bidders. Which was frustrated if a high turnover criteria was prescribed, which would prevent competition and would restrain the competition amongst limited persons, public bidders. Anything I left out?
No, my lord.
Next, per contract, comma,
My lord, the act, we have been supported by the act. sir.
Yes.
Assam Public Procurement Act 2017.
In support of the summation. The learned senior counsel for the petitioner is referred to the Assam Public Procurement Act, 2017. As well as Assam Public Procurement Rules, 2020. And it is submitted that as per the
My lord, section 4 and section, my lord, 6 also contemplates what we are submitting. And the object of the act, 3 things, my lord. Object, section 4 and section.
as per the object of the said act. The purpose of the said act was to provide fair and equitable treatment of bidders and to ensure that there was equality towards its bidders.
Four, 1B, my lord.
By referring to section 4 within bracket 1 within bracket small b of the said act, it was submitted that the fundamental policies of public procurement was to ensure
And my lord,
the
6,
responsibility and accountability of the procuring entity and for maintenance of transparency within bracket, including consistency, objectivity, predictability, openness, bracket closed, fairness, bracket including appeal rights, bracket closed, equality within bracket including non-discrimination, bracket closed, in relation with the bidders.
and my lord, clause number 6, 1. Which is very important.
First, by referring to section 6 within bracket 1 of the said act, it is submitted that the purpose of the said provision was to ensure wider participation of the bidders, as the said provision required that the procuring entity shall not establish
Any requirement.
any requirement aimed at limiting participation of bidders in the procurement process that discriminates against or amongst bidders or against any category thereof, except when authorized
Or required to do so.
or required to do so by this act, by the said act, or the rules or guidelines framed from time to time. Next, per contract, the Learned Advocate General has submitted that the respondent number 3 had invited bids for supply of 3,90,00,000 Napier NAPIER slips required to be delivered within a period of 3 days from the date of supply order to locations at district agriculture offices in the state of Assam. Hence, comment is something that as the entire supplies was required to be made within 3 days, unless the supplier has the financial meets the financial criteria, including the turnover criteria. Comma. The purpose of procuring Napier slips would be frustrated. In view of the requirement of making a timely supply. Stop. It is by referring to the statement made in affidavit in opposition and documents appended thereto, comma, it was submitted that as the bidding process is financed by World Bank, comma, the bid document was prepared and sent to areas AR. What is the spelling?
ARIAS.
ARIAS. ARIAS Society.
Page 230, Lordship will see.
No,
Yes.
I'm coming to it. I just wanted that name correctly.
Yes, Arias, a project coordination. It is an autonomous body of Government of Assam, Project Coordination Management Unit for World Bank Finance Assam Agriculture Projects. That is at page
Pusta.
230,
Okay.
down below.
Oh, okay, okay.
The whole
It is-
purpose of this authority.
It has been submitted that ARIAS, Areas Society, is an autonomous body of the Government of Assam for the purpose of project coordination of the management unit for World Bank financed Assam agribusiness and rural transformation project within bracket APART bracket closed and Assam citizen centric CNTRIC service delivery project within bracket ACC SDP bracket close. Accordingly, it is submitted that the said society is the authorized agency for coordination and management of the World Bank Finance Project. Accordingly, it is submitted that the draft tender of the notice inviting bid was sent for approval to the State Project Director, Areas ARIAS Society. Which contained the turnover clause turnover criteria. First of all, however, it was noticed that in the bid document, the said clause somehow got deleted. And accordingly, not the prior to the and the same was approved by the Areas Society. On 22/3/2023. And thereafter, the sale of tenders, of the bid document commenced on 27/3/2023. Full stop, however, comma, as it was noticed that the bid document did not contain the turnover criteria. Within 3 days, the corrigendum dated 30/3/2023 was issued to incorporate the turnover criteria. Full stop. Next, by referring to clause 8 of section 1, instructions to bidders is a part of bid document. It is submitted that that under clause 8, the tendering authority had reserved right to amend the bidding document by issuing addendum. Which is envisaged to be made a part of the bid document, bid of the bidding document. And in order to, and it was also envisaged that to give prospective bidders reasonable time for taking addendum into account in preparing their bids, the respondent authorities had reserved their right to extend the deadline for submission of bids. Full stop. Accordingly, it is submitted that as the sale of bid documents commenced on 27/3/2023 and the corrigendum was issued on 30/3/2023 with the last date of submission of bid being 27/4/2023, the petitioner had sufficient time. The petitioner as well as other bidders had sufficient time, and therefore no prejudice was caused with the issuance of corrigendum to include the turnover clause, the turnover criteria clause. Full stop. In next paragraph, in support of the submissions, the London Advocation has cited the following cases. The 6 cases. You please send your those citations. No, three you had cited.
3 and yes,
You flex,
yes,
then National High Speed and this Agmatel.
yes.
Just pass it on. So I don't have to open this e-mode and then read. At the outset, the court takes note of the fact that the work in question is a World Bank funded procurement. Which is aimed to provide Napier slips as a part of Assam Fodder Mission. Full stop. As only 3 days time is found to be granted to the successful bidder for supply. From the date of supply order, comma, it must be understood that the Napier slips, which is an agricultural product, would have a limited lifespan. Full stop. Although in the bid document, comma, the estimated amount of tender has not been mentioned, but in the affidavit in opposition filed by the respondent number 3, it appears that the estimated amount has been quantified at rupees 11.70 crore. The next, the learned advisory has obviously been able to satisfy the court that the from the contents of the communications dated 16/3/2023, by which draft of the bid document was sent for approval, as well as the response by Areas Society on 22/3/2022 of approving the draft bid. That the bidding document has been finally vetted by the Areas Society, who is a
Monitoring authority.
monitoring authority, as well as coordination and management unit of the for the World Bank finance projects. I have to continue at 2. This some
My colleague will be here, Lord.
Mix में कोई बात है ना?
But it will be down years. It will.
Bombay এই দুপৰীয়া টিফিনৰ এইটো ডাব্বা বুলি কৈছে তাৰ এখন মানুহ বিৰাট বিখ্যাত বোম্বে লাখ লাখ মানুহৰ এইটো দুপৰীয়া চাপ্লাই দিয়ে প্ৰথমতে এনেকে 10জন 20জনক দিছিলে ডাব্বেৱালা এজনে মানে আৰম্ভ কৰিছে এতিয়া বাঢ়িছে মানুহ ডাব্বেৱালা এইটো ডাব্বা বুলি কৈছে নাই সেইটো মানে মই ঘৰৰ পৰা চলাই দিছো বিৰাট নাম আছে তেওঁৰ খানাৰ বহুত নাম আছে আৰু টিফিন বিলাক কিন্তু তেওঁ নিজৰ নিদিয়ে মালিকে দিয়ে এই টিফিন বিলাক তেওঁ কেতিয়াও ভুল নহয় ক'ত যাব মালিকৰে টিফিন বিলাক কিন্তু ক'ত যাব কথাটো বুজা নাই সেইটো ভুল নহয় মানে চব বস্তু নাখায় নহয় কথাটো বুজা নাই মই আনিছো বহুত ডাব্বা আনিছো মই মানে 1 বছৰ ধৰি ৰেগুলাৰ আনি আছো এদিনো মিছ নাই খালি শনিবাৰে নাম
हम और बिल्डिंग में आ रहे हैं अभी निकल रहा है ना कि हाँ
লক্ষ্মীন্দর আছে লক্ষ্মীন্দর সব মঠগুলির ঘটনা আছে আছে তার মধ্যে
বেছি সময় নচলে তাৰে ডিক্টেশ্যন দি থাকোঁতে মিটিং চিটিং আছে নেকি ভিতৰৰ পৰা আহি পেলাই জামাদাৰজনে মাতিলে এই দুটা বজাত যদি ছাৰে এইটো আৰম্ভ কৰাৰ মিনিট চলি খুব বেছি আৰু ডিক্টেশ্যন দিয়ে মানে কি আৰু এতিয়াতো একবাৰে কিন্তু তাত থাকিব গম পাই যাব
মিটিং
এটা চলিলেতো
থাকিব
হয়
কিমান আছে থাকিব ডিপাৰ্টমেণ্ট কৰিব ডিসকাশন হয় কামগুলা আগোটা প্রুফ হয় তুমি কি করতে শুনবে পানি করছে না क्या कुछ খুব তুলে ফেলে কুসু 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 কাণ্ড খাই গাঁদা পায় তো ভালো কুসু हरिओ खाए पादो खाए मैं इतना मुझे बिलिंग ना दे मुझे बीट रिस्क ना बिलिंग अगर ये बिलिंग का बोनस ना मिल गाजर दूसरी दिन शुरू दूसरा आगे छोड़ दे हैं मुझे पैसे Fiesta boa, sim. Como tem essa?
আজিকালি মানে ছোৱালী বিলাকে তেনেকে diabetes injection নলয়তো। সেইকাৰণে মানে কথাবিলাক ধৰিব লাগে। এই যে উদ্ধৱ শৰ্মা ছাৰৰ যে কথাটো অলপ মই ফল' কৰি আছোতো, এই যিটো ল'ৰাক মই পুতেক বুলি ভাবিছিলো তাক আজি সুধিলো কথাটো, ছাৰৰ ছোৱালীজনী আপোনালোকৰ চেম্বাৰতে নেকি? কৈছে নহয়, তাই মোৰ চিনিয়ৰ। চিনিয়ৰ মানে এতিয়া তাই আকৌ বেলেগ চিনিয়ৰ লৈছে নেকি? তাইতো সৰু ন, তাই আৰু ইমানটোতো জনা হোৱা নাই। কয় নহয়, তাইৰ হাজবেণ্ড আৰু মই তাই আমি গোটেইকেইটাই মিলি কৰো। কিবা হেৰি হলে ছাৰো আমাৰ ওপৰত আছে। তাইৰ হাজবেণ্ডটো কোনটো জানে নাই? এই APDCL-ৰ হয় মণিপুৰৰ পৰা যে এজন পাৰ্চন মানে পাৰ্চন হৈছিল, লাইটৰ বিল চাপৰকে ল'ৰাটো যে খুব যে ভালকে দিছিল আৰু জোৰে জোৰে সি মানে শৰ্মা ছাৰ পায়। তাৰ নাম সমাগত শৰ্মা, এছ শৰ্মা। এই চাপৰকে
জানিছো স্মাৰ্ট
স্মাৰ্ট চুকাও মই এই সি আৰু ছাৰৰ নিজৰ ল'ৰা, মই সুধিলো ছাৰৰ নিজৰ ল'ৰাটোতো ল কৰিছিলে, সি APDCL-ত ল অফিচাৰ। পাৱাৰ আছেতো, এই ল অফিচাৰ।
The court is demanded of the observations of the Supreme Court of India in the case of National High Speed Rail Corporation Limited within Becker Supra, it was cited by the learned Advocate General that the scope of judicial review in such foreign funded contract should be far much less than the ordinary government funded contracts. Full stop. The said paragraph 37 is expected below. Next one. The present notice inviting tender is for procurement of Napier slips, which is required under the Assam Fodder Mission. Being an agricultural input, being a plant input, comma, the Napier slips have a lifespan for which timely delivery period of 3 days is envisaged. Full stop. We have a plant grown, it requires conducive weather and other factors. Therefore, comma, if the present tender is cancelled only because of the corrigendum dated 30/3/2023, by directing the respondents to incorporate this said clause in the tender itself, would merely postpone the procurement process, which is not for the benefit of the beneficiaries or the government in the Directorate of Agriculture. Next, the tendering authority is the ultimate master of the tender document, and the requirement of having a turnover criteria cannot be said to be so absurd that it can be read down to mean that it is in violation of the of section 4 and 6 of the Assam Public Procurement Act, 2017. Full stop. The corrigendum was issued on 30/3/2023, while the last date of submission of the bid was 27/4/2023. Therefore, this is not a case where after the petitioner had submitted his bid, that the respondent number 3 woke up to alter the eligibility criteria by prescribing turnover criteria. So as to, and therefore it is not acceptable to the court that the insertion of the said clause was to oust the petitioner from competition. Full stop. It is not the case of the petitioner that its bid was submitted prior to issuance of the origin 33/2023. Full stop. Therefore, comma, the court is unable to accept that the insertion of eligibility criteria in form of turnover criteria is arbitrary or discriminatory, or is aimed to oust competition. Full stop. Next paragraph, the learned Advocate General has demonstrated from the stand taken in the affidavit in opposition that the respondent number 3 envisaged the supply to have estimated cost of rupees 11, 70, 0, 0,000 within bracket 11 crore 70 lakh rupees, 11 crore 70 lakh. Yeah. Rupees 11 crore 70 lakh. You're getting it now? No. Therefore, comma, the petitioner is required to mobilize funds to the extent of rupees 11.70 crore to procure and supply the Napier slips of now to supply 3,90,00,000 Napier slips within 3 days. Next paragraph, the petitioner has not been able to satisfy the court that if he did not have an average turnover of rupees 4 crore for last 3 years, comma, how would we meet the finances to make supply to this extent? Therefore, comma, for the state to include a clause for turnover criteria cannot be said to be absurd. And therefore the court is unable to hold that merely because our turnover criteria has been incorporated in the tender by way of corrigendum, comma, the respondent number 3 had acted arbitrarily. Or in a malified manner. So it cannot be said that the inclusion of turnover criteria is irrational, irrelevant, or discriminatory. And has no nexus for the purpose sought to be achieved. Full stop. Okay, court is unable to accept that if a intending bidder does not have a certain turnover every year, he would be able to make supplies worth rupees 7.70 crore in 3 days. Next, the learned senior counsel for the petitioner had projected that assuming that the supplies was for a value of rupees 11.70 crore, insisting on a average annual turnover of rupees 4 crore for 3 years, would amount to requiring turnover criteria of 12 crore rupees. The court does not find any merit in this submission because the turnover criteria cannot be read to mean that the tendering authority is requiring a turnover worth 12 crore annually. It merely says that the turnover of the intending bidder should be would be on an average rupees 4 crore annually. This would also achieve assurance to the tendering authority that the prospective bidder has its existence for last 3 years and has been having a steady turnover, which would indicate that the business of the supplier is intending bidder is consistent and dependable. Next, therefore, this is not found to be a fit case where the court would substitute its own wisdom over the decision taken by the tendering authority to incorporate the turnover criteria. Next paragraph. As the learned advocate general for the state has demonstrated that under section 1, instructions to bidders at clause 8 thereof, it was envisaged that the tendering authority may issue a corrigendum, addendum, which would form a part of the bid document. merely because there was no clause in the initial tender document requiring turnover criteria would not dissuade and cannot prevent the tendering authority from adding the said criteria by way of a corrigendum. The said decision has its basis as the bid document which contained such a clause was approved by the areas society within bracket. No, so the areas society, by the communication dated 22/3/2023. Therefore, the decision of the tendering authority to incorporate such a clause by way of addendum cannot be a subject matter of judicial review, as the decision-making process cannot be said to be vitiated merely because a clause has been inserted by way of an corrigendum. More so when clause 8 of the clause 8 of section 1 of the bid document confers power on the tendering authority to issue a corrigendum. Next one, according to the challenge made in the present repetition phase and the repetition stands dismissed. First of the parties are have to bear their own cost. Yes, you wanted to say something? You wanted to say something?
No, my lord.
Okay.
I'm obliged, my lord.
Lordship, there was an interim order that
Okay, interim order past status stands vacated,
On 26/4, my lord,
26/4/2023.
2023.
I'll return you this tomorrow, this
My lord,
act, and
my lord, can retain that copy.
you'll need it more. You can always produce it. Your citations also, you get it tomorrow. It will be one paragraph each of that quoted here. You can collect it from the court master tomorrow.
My lord,
yes, ma'am.
I'm highly obliged, my lord.
Number 3. Just a moment.
Please, your lord.
Yes, just a moment. Mr. Sharma, senior counsel, you are waiting for which item?
Part 2, item 7.
Part 2, item 7. Okay, after this, we will jump there.
Lordship, I had a contact with the petitioners. Out of 5 petitioners, I can, Lordship, collect 3 extension of the bank guarantee, my lord.
Till valid, it's valid till
Yes,
today.
yes.
Okay, then we'll hear it.
In fact, I have also contacted the railways, my lord. They said that he is controlled by the financial advisor. He needs some time because he has to confirm with the bank, my lord. So 2 to 3 days time is needed according to them. But she has given me a copy that at least 2 or 3 of them has been renewed.
So that means everybody would have done it.
Most probably.
Okay, then we'll hear it on well. Now, what has happened to the Supreme Court matter?
My lord, that is pending, my lord, for final disposal. The other side, they had appeared, my lord. They filed their affidavits, was pending for disposal.
Now, this
Okay.
matter is based on the merit of the case, my lord. The document which they have exhibited at the time of hearing, my lord. That document may kindly be perused, my lord, which I have annexed with my petition, lordship.
Excess weight is 16.32 ton.
Yes, my lord. And they have provided me the annexure 16, my lord, that is at page 87. This is the failures of the weighbridge.
Yes,
87 is, my lord, the weighbridge remain out of order, and these are the failures noted down, my lord, from period 2/12/2000 up to 11/3/2005. And the said consignment was weighed on 26/7/2005. Thereafter, my lord, I have also annexed another failure particulars of the weighbridge, my lord, that is at page 89. In that period also, my lord, major failure was recorded, my lord. That weighment suspended by CFM Maligaon, which you will lordship find at
your weighment was on 26,
7/2005.
7 to that time it was working.
It was good.
No, my lord. Prior to that, my lord, 25/7/2005, there was a failure, my lord.
No, that's okay. Yesterday I would have been sick. I did not come to court.
Yes.
Today I'm well, I have come. So even if you get my prescription, that I was,
But the law says, my
I
lord,
was,
if the weighbridge is out of order, then my lord, they have to obtain re-verification certificate before the same is being used, my lord. My lord, the law says is section 26, subsection 3 of the standards
no,
of
see,
vehicle business.
you must first show that when these, what you call failure particulars are given by the inspector of legal metrology,
Yes, my lord.
there cannot be a presumption that for other period it was working well. You get my point. You see, it's not a certificate of XYZ. It's a certificate given by the inspector of legal metrology. So if he says that the machine was bad on say 1st of January to 2023, that would mean that for other days it was working.
But my lord, prior to that, my lord, on 3/7/2005 to 22/7/2005, there was a track switch problem again on 24/7/2005 to 25/7/2005. Same problem, my lord.
No, correct. You
Again,
see,
my
My
lord,
lord,
you
these
see-
are all minor
No,
problems,
no,
my lord.
you see, Mr. Sharma,
It does
you
not
see,
need, my lord, repair, my lord.
today morning, when I started the court proceeding, the mic created a problem. Correct. It gave a loud emanating sound, silent type sound it came. It disturbed the court proceedings for at least 2 minutes. So we all had to keep silent. The machine was switched off, then again this was put on, and now it is working.
now it is working. True.
Correct. In midst of the dictation, my secretary said that I can't hear. So we had to increase the volume. So that therefore he could take the dictation. Now you see, it means intermittently a machine may not be working. But does it mean for the entire day there is a what you call disruption in the equipment? There can't be a presumption.
Not only that, my lord, another document that was exhibited, my lord, that is unloading tally. At the time of my lord delivery, the entire consignment was delivered as per the railway receipt. This unloading tally is, my lord, at page 78, annexure 13.
Yes.
Except, no, 40.
Page 78, 79, my lord,
just-
remarks are there.
Just now. Page 70 is unloading tally.
Yes, my lord.
$78.
Up to page 83, my lord. 78 to 83. Here it was mentioned that all the above wagons bags all those such and such sugar was correct as per card label. Everything was received as per card label, my lord. So, no excess weight has been found, my lord, at the time of delivery.
It was not weighed at that time. Was it
Yeah.
weighed?
No, my lord.
It was not weighed.
Where is the said to contain, my lord?
No, at
Because
the
it
time
was
of
on the truck.
delivery.
No, I'll come back to
Directly
you.
loaded to the
Let
decks.
her complete her part. She may have her own way to explain.
This unloading process was done on yes, done in presence of both the parties as well as my lord, railways. And the endorsement with regard to the delivery is also recorded.
Mr. Sharma will know when I'm speaking of something. He will, Mr. Sharma, senior counsel, he will know of it. You see, one day what happened was, in the civil court, a lawyer was walking away and suddenly the court staff reached to him and found out that a court record accidentally went away with him. So you see, the fact is that something is gone. Whether it be a recorded, what you call exit, or it may be a inadvertent exit. But what is happening is that nobody makes a tally of the quantity when it is leaving the premises. It's not a requirement of the railways that each and every consignment must be weighed and then taken out. So if the, as Mr. Bhargava said, that set to contain. So set to contain is always set to contain, unless it is reweighed and then found that it's weighing more. There can be other reasons ascribed. Number one, it may be that during the course of transportation, you may take a plea that yes, there was a rain, it was not properly packed, and therefore there's an increase in quantity. Number two is that there's no such intermittent factor like rain and all, which would damage the sugar. Sugar was being, so sugar, the weight has increased, or due to huge temperature, there's a chances that sugar will, what do you call it,
Moisture.
moisture content will, it will leak, and this, what do you call it, it's not leaking, it becomes desolidified, and the moisture content increases. That can be also part. Those are not there. So number one, your first defense is, what I have read here, is that number one, that after the weighment, so that weighing scale has been restored, there was no certificate by the railways. They could not produce a certificate that the that condition was restored. Correct?
This certificate has to be obtained from the weight and measurement department.
Weights and
Okay.
measurement department. Now, please tell us, since I don't know, I'm asking you. See a small trader in the road, he will be selling, say, potatoes. Every weighing scale is the measurement, measuring, what you call that, what do you call it?
The weight-
Measuring weight has to be marked by the meteorological department. Correct? So once it is there, it remains valid for a year. Correct? So if there is a tampering in that, and when they are caught, they are given their challans are issued, and they are required to pay fine. Correct? Now, I'm asking it with regard to this weighing scale. Supposing it goes bad, it is recalibrated and made working again. Is it a requirement under the Act? Because in the Weights and Measurements Act, I don't find there is any clause requiring that after every recalibration, there'll be a requirement of certificate. If it's there, I missed it. Assam
Yes, my lord.
Assam
It was weight
weights and measurements
within
rules.
jurisdiction of the West Bengal, my lord.
No, it's okay. This weights and measurements rules, is there any requirement that every time it goes bad, recalibration must be authenticated by the by the meteorological staff? Is it required?
My lord, as per section 26 subsection 3, my lord, it is required.
Please show me that since I'm not aware. Twenty-six.
26 subsection 3, my lord.
Okay, you are right. Yes, Mr. Gorgodaki,
Lordship.
if that is the requirement of law, then the burden is on you to show that after this restoration of the weighing scale, you had it recalibrated, otherwise the petition has to be allowed. That is the only point.
Lordship. In fact, if your lordship take up my affidavit, that's on page 12.
Page 12.
That was the instructions given to the railways, my lord, issued by the Ministry of Railways, my lord. If some calibrations, inspection or verification of the way bridges are done, my lord,
Hmm.
it is done only once a year, only in case of major breakdown. That things have to be repaired. Then the fitness certificate should be issued. But here, if a lordship sees, these are all small problems, my love, digital problems. Sometimes it was stuck by lightning, it switch off. But the thing which was sealed by the weights and measure department, that was not tampered with, that was not touched, my lord. So in that case, my lord, new fitness certificate is not required, my lord.
Goes against 26.3, which she is showing.
That is what my lord says for repairing, my lord. If there's a major breakdown, if something is repaired,
No, you see, same example in the morning, this was not functioning. We had
okay,
to do something to make it work.
like, but that is not repair, my lord. Because the railway board circular also says that only. If major breakdown is there, if something is to be repaired, then new certificate has to be issued, my lord. But for calibration or some switch problem, those things are very minor, my lord. For that, certificate is not necessary.
But then you have to explain that these are minor, it did not require a repair of the instrument.
My lord.
That you'll have to demonstrate because I have no idea of any of these, what do you call, notes made. Page number
But
was,
once it is, my lord, verified and inspected by the legal metrology department, my lord, they put a seal on it. That those seals are not broken. Well, if we break the seals for making major repairs, then fitness certificate would be necessary. But say some switch has gone off, we replace the switch, that is outside, my lord. For those things, my lord, then a new fitness certificate is not necessary.
no, because I would not have any idea.
May I submit, my lord?
Because that is what have been said to me, my lord. In fact, in my affidavit also, I had stated that only.
Wave machine not responding.
So they just check what is the problem with that. At the very number one first day, it was struck by lightning. So the switches were not working. They inspected and see, but it is not with the machine, my lord. But I also, my lord, don't know how that exactly, how does moving in motion trains are serviced or they use it.
At page 88, my lord, weighing machine was declared out of order, my lord. That is on 11/3/2005. Thereafter, my lord, they could not produce any certificate, re-verification certificate to prove that the weighbridge was repaired, my lord.
But you just caught me in my own example. That this was not working without any repair, it started working again.
My lord.
This I put it off and on, and it started working. So he has caught me in my own example.
My lord, say,
So
like,
if an
the switch, my
equipment,
lord. If
if an
sometimes the
equipment,
switch goes off, my lord, it's bad. Like this switch, we can buy one and replace it. That is not a major repair, my lord.
it does not require recalibration.
Also, my lord, they could not upload that excess goods, my lord. As per the requirement of the section 73 of the Railways Act 1989. It is mandatory on the part of the railway to offload the excess goods. That was also not done in this case, my lord.
Then you won't succeed.
My lord,
Then you won't succeed. You see, page 89, just prior to that, there's a problem which is referred to 24/7/2005 to 25/7/2005. It
The track
says
switch, my lord.
track switch problem. So
Sure.
track switch problem is just merely a switching problem which disables a train to travel into the down track. Correct. It has got nothing to do with weighing machine. There was a switching problem with the railway track. That switch by which they change over from the side track to the down track, that was not working.
my lord, kindly see serial number 3, my lord, prior
No,
to,
you see, 27/7 is the date.
yes,
So we go to 25/7 only, 24/7 to 25/7.
True.
That is track switch problem.
And thereafter, my lord, from 25
This is
till 12/8, my lord, that's
the
working perfectly.
internet says it's a mechanical installation enabling railway trains to be guided from one track to another. Got nothing to do with this weighing machine.
Weighing machine, my lord.
but my lord, on 28/5/2005, payment was suspended, my lord. and it was declared by CFTM.
It's
my
okay,
lord.
payment is
So if
suspended.
it was suspended, my lord, then major failure was already prima facie, my lord, cleared that it was a major failure, my lord. And thereafter, my lord, if we consider this act, my lord, section 26 subsection 3, my lord, this will be applicable, my lord.
No, suspension may be for any other reason.
And
Payment is suspended.
If a lordship goes to
before that,
this
drilling machine also turned
maximum
off due
problem
to
is with the
lightning.
track
It's
switch,
okay, you
my
see,
lord.
there are two gates here. I stop one gate because of the repair. See, I will say in the court master will write for the court working description that one gate is suspended. Let us say, for example, he doesn't write that, but let us say he writes a note that one gate is suspended. Other gate is working. So the lawyers and the staff use one way and then we switch off the another. Doesn't mean that there is any inherent damage to the machine.
But my lord,
Payment is suspended.
on perusal of the said document, my lord, it is clear that frequent failures were recorded, my lord. And based on this payment, my lord, excess goods were like detected, my lord. Frequent failures cannot be a reason to declare the weighbridge is fit, my lord. Moreover, my lord, the subject consignment was booked in a standard size, that is 100 kg. It's a standard size bag, my lord. It's a sugar consignment, so it was bagged in a uniform size, my lord, that is 100 kg. That I have annexed in my petition against.
Okay, that's all.
Further, my lord, as per section 73, the law says, my lord, that it's a proviso to section 73.
Railway Act,
Yes, my lord.
Railways Act. Yes,
My lord, the proviso says that provided that it shall be lawful for the railway administration to unload the goods loaded beyond the capacity of the wagon if detected at the forwarding station or at any place before the destination station, and to recover the cost of such unloading and any charge for the detention of any wagon on this account. So it is mandatory on the part of the railway to offload the goods where it is detected, either at the forwarding station or at any place before the destination station. No
no, it
access.
says, it doesn't say mandatory, it says provided that it shall be lawful for so and so.
Yes.
Doesn't make it mandatory.
But my lord, another rule 1877, it is also make it mandatory, my lord. Indian Railway Commercial Manual.
No, but then who will pay for that unloading and all? So supposing, let us say that there's a rake of, let us say, I don't have the idea, say 52 wagons. There's a overweight detected. So who will pay for the unloading of the,
That will be bear by the petitioner party itself. If it is detected, then the detention charges and other costs will be bear by the.
which
Consigned.
provision you say is made it mandatory?
73 CC.
Huh?
73 sub 73.
No, you're referring to something else, 89 or something.
1877.
The bus. Why? It is manual.
Section কি বলছিস
Daily manual.
IFC
My lord, FE 77 is the relevant rule.
The railway reserves the right. Does it mean the mandatory they will do it? This cannot be read to be a prescription that they mandatorily they will have to remove it. Because you see, I wrong back, I forgot. I think there are certain judgments also which says before taking punitive action, you must be given a reasonable opportunity to show cause. So it's not that in a moving train, they will offload in the name of excess quantity. You see, certain things it's not very palatable. Let us say that a train is moving from Guwahati to Bongaigaon. In Rangia, excess quantity is detected. And you are proposing that at Rangia, they will offload the goods. But then what happens to the opportunity of you to be heard?
My lord.
Because then
opportunity of
they will
hearing
detain
is
the train
required
at
because
Rangia. No, I'm just understanding your proposition. They will detain the train at Rangia, give you a notice to show cause, and you will take 2 days time to go to Rangia, have it checked, and then there's a dispute. And all this time, this train will
2 days my lord that will be standing in the
will keep on
station.
standing there. It's not the proposition I can accept. So
before leaving, my lord, an opportunity must be provided because
Is
they
it,
made.
you see, no, is it your case, Ms. Sharma, that the overweight which was detected in your case exceeded the total, what you call, loading capacity of the wagon? Is that your case?
My lord, their allegation is we have loaded excess goods.
No,
My
excess,
consignment was booked in the
no,
standard.
Excess in weight.
excess means there are two types of weight, tar weight, axle
Tar weight.
weight,
Yes.
correct? Now, is it your case that the goods which were the excess load which was detected exceeded the tire weight and the axle weight?
Exceed, yes, my lord, beyond the permissible carrying capacity. Beyond the weight of the wagon.
Beyond the weight of the wagon?
Yes.
Where is that?
Their demand says, my lord, impugn demand. Page 38, my lord, annexure 1.
But you see, there's been interpreted by Calcutta High Court. This C was not brought to my notice. C says whenever the railway administration does not offload the excess weight on operational considerations and to save detention to wagons or other reasons and allow the wagons to move to destination as it is, it will be within its right to recover penal charge for excess loading as provided in the goods tariff. So it's provided in 1877C.
My lord, in this case, my lord, there is a judgment of the Honorable High Court, my lord. Here, the Honorable Court held that railway must satisfy the court that the weighment taken is correct. If it is correct, then my lord, they have to establish by producing the proof of the weighbridge that whether the weighbridge is fit on the date of payment, my lord. On that period, my lord, they could not establish that the weighbridge is fit because there are frequent failures noted in the chart, my lord. And the law says, my lord, that if it is out of.
Show me that judgment. Which paragraph?
Paragraph 33 is relevant, my lord.
Okay, anything else?
Lordship, these are my submission, Lordship.
Yes, Mr. Bargatagi.
Well, in fact, they have taken two pleas, my lord. Basically, that, my lord, the Weberys was not functioning at that point of time when it was measured. And secondly, my lord, that hearing opportunity has not been given to them, my lord. I have filed the affidavit, my lord, in this case. And where is my annexer 7, my lord, the affidavit shows that, my lord, on that day the weigh machine was performing correctly, my lord. There was no error in it. And secondly, my lord, giving them the opportunity of hearing, my lord, they were called to the office, my lord, but they did not attend, my lord. They said that at a point of time in Lamding, some situation was not good, but what situation was not good, my lord, we do not know. We called them, but did not attend, my lord. Thereafter, they again filed a writ petition saying that at that point of time, that Lamding was not a safe place to travel, so they did not go. Thereafter, they took out new plea, my lord. Some documents were not provided. Thereafter, this honorable court ordered that some documents has to be provided. All of that also receipt that I have annexed in my affidavit, my lord, at annexure 4. All the documents were provided to them. But thereafter also, my lord, they did not come up for hearing. And they can file this fresh case. This is the third case, I think. On the same issue since 2005, my lord, it was continuing. And the only thing they have to show that at that point of time, the Weberys was not functioning properly, my lord. That they could not. Regarding, my lord, those annexures in case 78 to 84, my lord. This is only the number of bags, my lord. This is the number of bags which was loaded, my lord, that was unloaded, and it is okay, my lord. It doesn't say anything about the weight. Because, my lord, what happens, my lord, in a rake load, all trucks, they come near the bogies, my lord, in the wagons, and directly from the truck to the wagons, all things are loaded. And they make a declaration that, yes, in this, say 100 bags are there. So the railway issue a receipt, which says said to contain. That is, that's said by the person who loaded the thing. So that is a receipt that has been given. But there are no supervision of those things. And secondly, my lord, no weighman was done. And in fact, at that point of time in the originating station, there were no weigh bridges. So on the journey, my lord, at Rangapara, they weighed and they found that it was overweight. Not much also, my lord. Beyond the carrying capacity, in some, my lord, there is say 1 ton, in some 1.5 ton. So like that, my lord, the penalty was imposed. Well, Lord, this issue is of 2005. In fact, my lord, now things have changed, my lord. Because in the destination stations also, my lord, there are new weigh bridges have been set up. So there is no problem nowadays, my lord. Because this kind of cases, my lord, they were filed in 2005, since say up till 2013. And thereafter, my lord, this sort of cases has stopped because in all the destination stations, although there is a in-motion weighing machines. So if on the way it is measured and found, then instead of giving an opportunity of hearing at the destination station, my lord, by payment of fees, they can check again. So this kind of cases, my lord, has come down nowadays.
Okay.
Lordship, the submission.
And
which
regarding,
was
my
made
lord,
by the respondent, my lord,
issuing
that
fitness certificate, my lord, only when, my lord, parts which are sealed by the meteorological department are changed then the new certificate has to be issued, my lord. Not for minor work which are not sealed, my lord. If your lordship goes through this annexure at page 14, my lord, in the affidavit, your lordship will see that it was shut down because of lightning. Then one is a digitizer problem. And all others, my lord, there's a switch, track switch was not working. It has nothing to do with the, my lord, in motion wing bridge. There are ancillary things, my lord.
Yes.
Lordship, the annexure 8 may kindly be perused, my lord. This is the letter that we have given to the divisional railway manager. And this is a proof that we have participated in the hearing, my lord, which was held on 2011-2013, my lord. We have clearly stated that, my lord, in terms of Honorable High Court order dated so and such, we have come to the office of DRM and NF Railway today for the desired hearing opportunity, my lord. So that submission is not correct, my lord.
The last paragraph. This I have read.
Which one, my lord?
Same page, page 62. See the last paragraph.
Page 60, yes, my lord. We have appeared and we have also requested to supply certain documents as per
That's
the
not a
direction
hearing.
of the Honorable High Court.
That's not a
That's
hearing.
not a hearing.
Because, my lord, the Honorable High Court setting up certain constraints, my lord, upon the railways that before giving any desired opportunity of hearing, my lord, they have to submit certain documents which we have asked in our previous letter, that is 4/6/2013.
So therefore, that is not a hearing.
That was supplied, my lord.
We have requested them because without these documents, we cannot sit for the hearing, my lord, because these
That's
are the
okay, but
crucial documents.
no,
which
it's
will-
okay, but that is not a hearing.
Because that day is the date fixed for hearing, my lord. So on 2011-2013, we have appeared, my lord.
But Ms. M. Sharma, Learned Counsel for the petitioner. Oh, sorry. What did we call him? And what about the allegations, Mr. Barkotaki, that documents are not furnished? Where is that? What stand you have taken in your affidavit in opposition?
In that regard, if you lost it. See exhibit. And annexure 4, my lord, page 11 of the affidavit. These are all the documents that they had asked my lord that was furnished to them. My lord.
Page?
Page 11, my lord. Annexure 4 of the affidavit. Yes, these are the following documents I sent to you for your perusal. Xerox copy of forwarding note, Xerox copies of loading tally, reweightment chart, fitness certificate issued by state government, weight and metrology department, daily check register, and the letter which was the penalty was imposed. My lord. Also, the document they asked for, my lord, that was provided. Our letter dated 8/1/2014. My lord.
But Ms. M. Sharma and the counsel for the petitioners and Mr. A. Barkotaki, standing counsel for the. You are standing, you will write your standing counsel or counsel?
No, my lord.
Counsel,
Right now, just the council, my lord.
Mr. Counsel for the
Actually, what has
respondents.
happened, my lord, after the CGS is taken over, my lord, all the new cases have been looked up by them.
Okay.
But the old cases that are pending, my lord, we are doing it and being
Okay.
paid directly by the railways, my lord.
By filing this representation in Article 226 of the Constitution of India, the petitioner is assailed. The demand notices dated 28/7/2005 issued by the Chief Goods Superintendent within bracket capital B full stop G full stop bracket close NF Railway New Guwahati, by which the petitioners were asked to clear the undercharges, which includes excess weight. I'm sorry. Which includes undercharges for excess weight as well as penal charges thereon. Next paragraph. In brief, the case of the petitioners is that they had booked consignment of sugar from which destination?
It was loaded to NGC goods, my lord. New Guwahati.
No, from where to where?
From KPD to NGC. KPD is, my lord,
KPD, Katapadi.
Katapati, Karnataka.
From Katapadi,
Yes.
KATA, within bracket,
KPD.
KPD
KPD.
for short, bracket closed, comma, Karnataka. With destination at Guwahati,
NGC, New Guwahati.
at New Guwahati. First of the booking and delivery of goods are not in dispute. Full stop. While the goods, while the consignment of sugar was en route to Guwahati, EMROUT, en route to Guwahati, comma, the rakes, it was a rake or wagon? Wagon.
Entire
The-
rake, my lord.
My lord, the whole train, my lord.
The rake was weighed at Rangapani, RANGAPANI, Way Bridge. And certain excess weight was found in respect of all the petitioners, which was beyond the permissible weight of the wagons. And accordingly, penal charges were imposed by the Chief Goods Superintendent within bracket capital B, full stop, G, full stop, NFL Guwahati, New Guwahati. For different amounts for the petitioners. Full stop. The petitioners had approached this court by filing a writ petition which was numbered as WPC 5597 of 2005. Oh, sorry, the first was here.
First WPC was, my lord, 5597.
5597, 5597 of 2005, wherein this court by order dated 10/4/2013 dispose of the petition in terms of decision of the full bench of this court dated 2/2/2012 passed in WA 333 of 2010 by providing that the railways, before taking any action for realization of the penal charges, shall give a right of hearing to each one of the petitioners. First off, this court also recorded that the penal charges are covered by bank guarantees offered by the petitioners. First off, it is projected that, next para, it is projected that despite several representations, the documents that sought for were not provided. And it is also projected that although after proceeding, also submitted, thereafter the petitioners were compelled to file another writ petition before this court, which was registered as WPC 6049 of 2013. And this court, by an order dated 18/11/2013, directed that all relevant documents sought for by the petitioners shall be made available to them by the railway authorities. And the petitioners would be at liberty to take extracts from such documents or take photocopies thereof. And it was provided that if some time is required for perusal of the documents and for making effective submissions based thereon, the railway authorities would grant further 10 days time to the petitioners. And it was provided that on the refixed date of hearing, the petitioners shall make their submissions, whereafter the railway authorities were given liberty to pass appropriate orders in accordance with law. It is projected that despite direction contained in the hearing before referred to writ petitions, the documents as sought for were not furnished. And in this regard, reliance is placed on representation dated 2011/2013. First, it is projected that just one more, 17/1/2014, 15/2014, comma 15/2014. First off, it is submitted that although the respondents claim that the required documents have been furnished, but by letter dated 8/1/2014, although six documents were shown to have been provided, but they had not received the photostat copies of loading tally, which was brought to the notice of the railway authorities by the hearing before referred representation dated 17/1/2014, 15/2014. It is projected that as documents are not received, the petitioners by their RTI RTI application dated 15/2014 required certain informations. Which are also not provided. And thereafter, the petitioners had approached the public information officer by a letter dated 30/9/2011 for information under RTI Act. Next paragraph. The learned counsel for the petitioner had referred to the Annexure 16, Roman 16 of the writ petition to project that the Way Bridge, where the payment of the consignment was done, was intermittently out of order since 2000 till 9/12/2005. Full stop. By referring to the provisions of Section 26 within bracket 3 of the standards of weights and measures within bracket enforcement bracket close act from 1985. It is submitted that unless a repaired weight or measure the repaired weight and measures shall not be put to use unless after repair it has been duly re-verified and stamped. Stop. Accordingly, it is submitted that the weight bridge remained intermittently out of order or non-functional from 2/12/2020 till 9/12/2005. Intermittently and that the repayment in this case was done on 27/7/2005, but the weighing bridge was out of order of the non-functional from 24/7/2005 TO2 25/7/2005, unless the unless the weight bridge is shown to have been re-verified and stamped, the repayment done by the railway authorities in the concerned weight bridge would not be sustainable. Full stop. By referring to the provisions of what is this called? 1431 will be what?
Indian Railway Commercial Manual.
Uh,
1439.
of serial 1877 of the Indian Railway Commercial Manual, volume 2, Roman 2, Now it is submitted that as the railways have stated to have detected overloading beyond permissible limit, the railway administration ought to have offloaded the excess weight which was not done, and the consignment was allowed to reach the destination. Was accordingly submitted that as the railway authorities had not followed para 1877 within bracket B of the Indian Railway Commercial Manual, Volume 2, no cognizance of an excess weight can be taken by this court. Full stop. It is by referring to the case of Nirmal Traders versus Union of India and others. Within bracket 2003, bracket close 2 GLR 429. It was submitted that a review done by the railway authorities cannot be acceptable because the railway authorities have not produced any document to show that there was an excess weight detected. In this regard, the learned counsel for the petitioners has placed reliance on paragraph 31.
Minus 33.
In paragraph 33 thereof, which is extracted below. Hence, comment is submitted that the railway authorities have not been able to prove that there was any excess weight detected. And therefore, the imposition of penalty on the petitioner was not sustainable. And accordingly, it is prayed that the show cause notice issued on the petitioner be set aside and quashed. Anything I have left out?
No, madam.
Next, for contact. The learned counsel for the respondents has submitted that there was no damage to any part of the way bridge which affects the detection of
Parts of way bridge sealed by Weight and Measures Department.
please repeat again.
My lord, there was no major breakdown involving parts of the way bridge that was sealed by the Weight and
Just
Measure
write
Department.
write the same language. There was no damage to the. Yes, please repeat again.
Involving parts of the way bridge that were sealed by the Weight and Measures Department.
And accordingly, the defects which were for which the way bridge was not functioning earlier was not attributable to any defect in the
Weybridge.
Weybridge, but they were minor problems which are unrelated to the parts which were the parts of Weybridge that was sealed by the legal metrology department. So it is submitted that a reasonable opportunity was granted to the petitioners to make their submissions in the hearing. But on one account or the other, the petitioner deferred the hearing. And thereafter challenged this, the show cause notice in the present date petition. First off, it is submitted that all the relevant documents were provided to the petitioner by forwarding letter dated 8/1/2014. So it is denied that. Where is that letter 8/1? Acha,
Annex
68,
4, madam.
68, huh? Submitted that. It is not accepted that the photostat copy of loading tally was not provided to the petitioner. Is it available now?
My lord, that loading tally matter originated in the Karnataka, my lord, where it was loaded. That is not available, my lord, but that is not important also because
No, you see, page 68, you say that you have provided.
no, my lord, what I have said is these are the, my lord, documents that were provided. Forwarding note, a xerox copy of loading tally,
So that means this provided, you
that
can't
is
say that,
provided, my lord.
so you can't say that it's not there because now you
My
are,
lord. Then
now-
realignment chart, then
No.
fitness certificate, and
No,
then
but if you're-
daily check register.
no, if you're forwarding it to them, you must have a copy and you should have produced it here. That you're not doing, why? Because in every letter, she is saying that this document was not received. And reiterating the demand of document.
But whatever was asked for, my lord, that was supplied, my lord. Like six items, my lord. And that was received by them.
But in this, in connection with the allegations of non-receipt of the loading tally by forwarding letter dated 8/1/2014, the learned counsel for the respondents has vehemently denied the non-furnishing of the said a document to the petitioners, and in this connection, he has placed reliance on an extra 4 to the affidavit in opposition filed by the
railways matter respondents.
respondents. And it is shown that the documents were acknowledged to have been received by the counsel for the petitioners under his signature with date of 8/12/2018. 8/12/2018. Your letter is of 14. Can be.
But they have also.
No, she is denying everywhere, not received.
No.
It can't be because this is a repetition of 14. So we said
My lord, in paragraph 17 of the writ petition, my lord. They have said that we have furnished the accomplice, my lord. The petitioner begs to state that the documents which were supplied by the respondent also does not show any discrepancy or overloading of the part of the petitioner. Copy of the unloading tally is provided by the respondents by letter dated H1/2014, my lord. They have received those documents, my lord.
It was about unloading tally.
Only my lord, outward loading tally book. That was not furnished to them, my lord. That I have in fact acknowledged that we have not given them that one.
no, that's not acknowledged. You are denied it. That's why I'm
No,
searching for
my
it.
lord, no, my lord. My lord, in paragraph 8, my lord. Since the consignment was directly loaded from the truck to the wagon, the contention of the petitioner that the outward loading tally book maintained at the booking point is a vital document is ruled out, and thus it was not supplied to the petitioner, my lord. We have acknowledged that we did not give them, my lord.
Okay, you just alter that.
All other documents were supplied
You
to
said
them, my lord.
all of the document except the outward tally book.
Outward loading tally book.
Maintained at the booking point was not supplied to the petitioner. So it is submitted that this document is not
Not a vital document, my
not a
lord,
vital document for the purpose of this case.
because the whole consignment was said to contain, my lord.
First of all, it is submitted that on the pretext of non-service of documents, the petitioners did not participate in the hearing. And thereafter, and after 2 rounds of writ petitions, the present writ petition has been filed. Next paragraph.
And further that, my lord, on 27/6, my lord, that the way mission was perfectly
Next. paragraph.
working, my lord.
Uh, The issue of the weighbridge being out of order on various dates from 2/12/2000 TO2 9/12/2005 is taken up first. In the present case in hand, the goods, the consignment of sugar, which was transported by the petitioners, was weighed at
Rangapani.
Rangapani station. Rangapani weighbridge or station, weighbridge, Rangapani weighbridge. On 27,
On
26/7, my lord.
26/7/2005. Full stop. Although the annexure
Seven fifty affidavit in operation.
Annexure 16, Roman 16 discloses that the weighbridge was intermittently out of order on various dates, but immediately preceding 26/7/2005, the weighbridge had failed to work on 24/7/2005 to 25/7/2005 for the reason assigned to be inverted commas track track switch problem within bracket capital DN bracket close inverted comma. Full stop. As per information available in the internet, a track switch is a mechanical installation to enable railway trains to be guided from one track to another. Full stop. Obviously, a rail track is not a part of the essential weighbridge equipment. So it is projected in this case that the railway bridge is suited for what you call on track. Mr. Bhagwati, it is, what is the right word? On track weighment.
In motion weighbridge.
Or is
my
it
lord.
in motion, mean motion weighbridge. And therefore, if the track switch had a problem, that had got nothing to do with the actual functioning of the weighbridge. Full stop. Under such circumstances, court is inclined to hold that if the weighbridge becomes non-functional because of track switch problem for down track DOW and down track, it cannot be said that the weighbridge had to be repaired to be restored, requiring re-verification and stamped and stamped by the authorities under the legal metrology department. Having jurisdiction over the area. Next para. Next para is of this, what do you call it? For this interpretation of this order or not, I passed orders in chambers because I'm keeping Mr. Sharma waiting. I won't have time. It will be, the orders will be delivered today.
Fine.
I'll pass orders in the chambers. The only point is acceptability of your argument on the correctness of Weybridge, and incidental issue is that non-supply of document. These two issues I'll deal with.
Only one document, my lord, that was the Advert telebook maintained.
Oh, that's okay, but that
Originating
is,
point only.
but there is a two items I'm leaving it out. I'll examine and pass orders in light of this decision, 2003 to GR 429.
Much obliged.
Much obliged.
No, sir. No, sir. Mr. Sharma, I'm calling up your matter. How's your health, Mr. Sharma?
Let him begin.
Okay, not a speaker. Mr. Mukherjee, make Mr. Sharma sit this side, otherwise his voice will not come. Otherwise, your voice will not come. Speaker is there. Yes, Mr. Sharma,
Yes, my
you
lord.
have heard Mr. Banik. You may keep on sitting. No problem. You have heard Mr. Banik. He says that the card which was issued
Hmm.
to the petitioner did not have this CVV, and therefore it was not possible to have this card used for any online transaction. That is his first statement. And then he says that the petitioner did not receive any SMS alert during the relevant time when amounts were deducted from his account. And he says that all the transactions were ATM transactions which could not have been done without 3D password. Because without this 3D password, he says that there cannot be any online transaction.
My lord, that fact is not correct, my lord. That statement is actually incorrect, my lord. In fact, my lord, initially 19-digit card was given.
subsequently, a 16-digit card was given as per his application. But the 16-digit card was never used. In 16-digit card, my lord, that provision is there regarding the OTP, informing sending the information about SMS and all these things. Entire transactions which took place were on the basis of the 19-digit card, my lord, which was held earlier, and all the transactions were taken on the POS machines, this point of sale machine, my lord, where only the card is inserted, the password is paid by the person who makes the purchase, and the transaction is complete. The question of sending any SMS does not arise. Asking for the CPC card does not arise. And my lord, as soon as the complaint was made, which was also a subsequent period of time, because it was detected by the petitioner later on, my lord, FIR was lodged, police was, all the informations were furnished, and the purchases which were made regarding the railway tickets by the agent, my lord, all details were furnished to the police. What more the bank could have done, my lord, except that the bank always informed the client that don't disclose the password, don't hand over the card to any third person as far as possible until unless it is your relative or somebody there. But the card is inserted in POS machine. The passwords are thereafter inserted, which are known to the customer. The bank people will have no knowledge about it. What are the passwords? Those can be changed also from time to time, and even always the customers are advised, the cardholders are advised that you don't keep it same password, try to change it at periodical levels. The bank has nothing to do with it. There is a carelessness on the part of the petitioner. He must have given the card to some of his close relative or somebody acquaintance to him, and we know all these things have happened. Simultaneously, before giving the card also, the password was also disclosed to him. And all the transactions have taken place at a particular place. In this case, the role was of the police to catch hold the culprit, but nothing was done by the police, my lord, and bank has nothing to do with it.
Sir. In reply, my lord, I would address on two vital issues. While I respect the views taken by the bank, as my senior colleague has addressed, my lord. But I'm confronted with legal issue, not the scientific angle. The law took its course once it was set in motion, and the SPCID has filed an affidavit identifying, if Lordship takes up the affidavit by the SPCID, the words are not challenged by the bank. The finding, the conclusion of the SPCID, whatever is in the affidavit, was never put to challenge by the bank.
It is not open to challenge.
No, yes. The statement of the bank is on a presumption that it was used at POS machine, it was swiped, password was given in a simple language, password was inserted, and that's how the things were done. In effect, I compromised. In effect, for them to sustain an argument of this stand, necessarily and invariably, this paragraph 9 of the affidavit by the CID has to be taken together. May I read the paragraph? Sometime in July 2013, it was filed.
You're relying on additional affidavit or the
Affidavit in opposition by the SPCID. Response number 2, 26th of July 2013, it was filed.
26 July.
Yeah, I can handle it.
No, I had it. 26 July
2013,
13.
13. It's hardly 5 pages. Okay. There are sections.
Yes.
Paragraph 9, page 3.
Yes.
Fourth line onwards, the crime. May I
Yes.
read? The crime has been originated outside the state of Assam, that is in the state of Maharashtra. However, the IO has visited Maharashtra in connection with the case to trace out the involved accused. In this regard, 12 IP addresses are found, out of which 2 IP addresses are found to be related to one Sarla Subhash Panjari of Central PS area, Ulhasnagar, Thane, Maharashtra. During investigation, the address of the suspect found as fake. However, necessary efforts have been made with concerned department to find out the addresses of the subscriber of the rest 10 IP addresses. Efforts are on to the logical ends of the case. And subsequently it says that IO was also detained in Thane. Now there are 12 IP addresses. The Lordship may take the affidavit, additional affidavit filed by the SPCID in 2019. We're in 13, now we have come to 19.
Yes.
Paragraph, page 4. The last paragraph. It starts from point number 1. On the last. May I read that now? The former IO Inspector Ghulam Mohammed submitted requisition to Nodal Officer CID Assam, praying to arrange for collection of IP addresses against the IP numbers noted in serial number 1. On receiving the requisition, the additional SP N. Moisture, APS Nodal Officer CID Cybercrime, put note on the body of the requisition directing the IO to collect report from the Inspector Deepak Kumar Das of CyberLab, and after 1 week. Accordingly, the IO mentioned in the case diary that till 16/10/2016, he had not received any report relating to IP addresses of those persons who are involved in the fraudulent transaction. The period was not 8/5/12 to 17/5/12 when the alleged transactions took place. Fresh requisition was submitted addressing the nodal officer CID Assam Ulubari Guwahati requesting to arrange for collection of IP addresses against IP numbers. Now the detailed thing is given with the time. My lordship, this thing which has been found out after an investigation by a body having jurisdiction carries weight. Presumptive conclusions reached by the SBI may be good to hear. I'm not on that. Anyone would say that password was compromised. Had there been no CID report on this, they could not reach the conclusion. That's one thing. That's one thing. But to say that I did it is quite another. When I read these two in juxtaposition to page 31 of the writ petition, and the admitted fact is there were 19-digit card was used. It says, and if I may read, bank has moved debit card issuance from 19-digit debit card with no card verification value to 16-digit debit cards with CVV and expiry dates in line with market to encourage e-commerce transactions on debit cards for which CVV is required. CVV is mandatory for e-commerce transactions. I pause. 16-digit card admittedly was never used. 19-digit card did not have CVV. The State Bank says under reply to RTI that CVV is mandatory for e-commerce transactions. The existing 19-digit cards do not have CVV code. There is no way to incorporate CVV on these cards. However, customers may apply for a new debit card with CVV. Now I put on the same page. Card I hold is a 19-digit. Mandatorily, the bank admits without CVV, no online transactions can be done.
No.
They say
This-
physical
that is-
transaction was done. I understand. They say physical transaction was done. They say it without any basis whatsoever. Investigation is done by the CID and the report of the CID before this honorable court. Bank is not assailing this. As on date, this is no one's case.
No, you see, that is unacceptable for a simple reason. You see, the bank, let us say police for in any other case, let us say a murder case or a theft case. The police does the investigation, records something in the case diary. Correct, that is not open to challenge.
No, I'm not on that. The stand of the CID is in conflict with the version of the bank on affidavit. Case diary is something which we are not privy to. The stand of the CID after interaction with the bank is here. And it is nobody's case. At least the CID does not say that I compromised. It mentions the place, the time, everything. And one more document which I had filed an additional affidavit. I just read it. I had annexed. This is to inform that I have received one SMS from LM SBI CRD as follows. Dear SBI cardholder so-and-so, card ending with so-and-so at Miraj Hotel so-and-so, 2613 has been declined. Please call so-and-so. When I telephoned number so-and-so, it was observed that it was a SBI customer care number, and I was informed that somebody had tried to hack my credit card. I immediately advised the customer care to block the card and issue one fresh card with a different number and electronic data. I have already received confirmation email regarding blocking of my card, as the transaction was tried by the hacker in payment terminal of a hotel. It is now very easy to identify the person, as the hotel must be in position to track and fail transactions. My lord, simultaneously, both my cards are being hacked. I also bring on affidavit this part. Although this case is on the debit card, on the same person at a different place and a hotel terminal, my credit card is being used. SBI informs me that it was declined. Then I tell them to block the card. These things are going on. So if they say that I parted with my credit card or I parted with my debit card, I provided everything, I have no answer to that, my lord. And one who can answer is in heaven. The only thing is the SPCID and the bank state stand that the CVV without CVV transaction, online transaction cannot take place. And here they give the IP addresses clearly. If I refer to the dates, 16/5 so-and-so, 19/5, 15/5 so-and-so, time, everything is given. Now the failure of the police authorities to nab the culprit does not put me in a position that I played fraud. The sum and substance of the entire submission is that the petitioner played fraud. Where I am before the authorities saying that please complete the investigation. I'm not fault finding with the bank. I'm never fault finding with the bank. I say in a situation when the entire society was going to a transition period, these things happen. My credit card was hacked. The bank tells me. My debit card was hacked. I tell the bank. The CID comes up with a version. This is not case diary version. Then on affidavit, they've taken a stand, not dislodged, not challenged, not at least.
The Supreme Police can't take a stand which is not supported by case, entities in the case.
No, I am not on that. What I'm submitting, my lord, is that if the public prosecutor places a case diary, I'm not privy to that. Bank is not privy to that in a bail application otherwise. But here in a writ petition, they have taken a stand based on record, based on investigation. Once the stand is there is no denial to this. Then no, this is wrong because he parted. That stand is not there. The investigation is in my favor, only it stops at a point when they cannot nab the culprit. But for the bank to say, I am the culprit without any material on record is a presumptive submission, my lord. That stand may not be allowed to be taken. On the facts, I'm arguing the case based on record, based on data, which are there on record. Gentleman has died. The cards are there, whatever thing, and the police has also admitted the fact. that the inspector who was there on charge failed to collect the SMS on the phone, and that is a lapse on their part. I submitted myself, I threw myself into the investigation, I cooperated with everything. Now the BSNL does not take a stand. I do not know whether the council is there or not, even not there. To take a stand why SMS was not there, at least someone should answer. There is no one to answer me, but I put the question to myself, where does a citizen go? I repose the trust and faith on the bank, on the system, and the system of hacking, rather than accepting the hacking, just to shrug out the responsibility that something had gone wrong, even the bank might be required to pay. The entire trust is being put on me, Miller.
Every day you open newspapers, you'll find that people have compromised their, what you call.
No one is
The-
compromised. What I'm submitting is that
The card details, account details, and money is being transacted.
it might
Yes, sir.
happen. It might happen in a case, but if I am not holding that affidavit by the SPCID, which talks otherwise and is a part of record, unchallenged. Unchallenged in the sense that it is not contradicted.
Okay.
But these things may happen time and again. Lordship kindly takes note that my credit card hack was also there. I filed a letter if you need to say this is happening with me, unfortunately.
Milord, the position of the bank is made clear, Milord, in the additional affidavit
Yes, sir.
filed in May 19, in para 6 and onwards, Milord.
Okay.
On earlier occasion also, my lord had it, and thereafter
Yes,
this
yes, yes.
additional affidavit was filed because of certain controversies which arose regarding to
19
number of
16.
cards. And my lord, everything was explained para 6 and onwards.
Okay. Mr. Asbani, counsel with the petitioner. And Mr. S. S. Sharma, and senior counsel assisted by Mr. B. J. Mukherjee, and counsel for the State Bank of India. And Mr. P. Hazarika, and counsel appearing for respondent number 3. So arguments are concluded, it has been reserved.
Blessed.
You want to say anything? You want to say anything? It's a pleasure hearing you after such a long time. I've seen you after a gap. How's your health now?
Yes. For the first time I have come in the year 2023.
Okay.
Here,
Okay.
much okay.
Item number 4.
This matter, perhaps the petitioners are agreeable to present their claims for the conservator of forest of that circle, and he'll adjudicate their claims.
Yes.
Yes, my lord. Until then, we may not be able to.
Yes, till that time we'll not.
Okay. But Mr. S. Dale and counsel for the petitioners, as well as Mr. A.P. Pathak, and standing counsel for the Forest Department, appearing for all the respondents. Next paragraph. At the outset, the learned standing counsel for the Forest Department has submitted that in view of the nature of dispute raised by the petitioner, as well as considering the documents filed in support of the writ petition, it is suggested that the petitioners may consider approaching the which authority?
Lordship, otherwise only the PCCF has been included as a party here, so perhaps let it be PCCF now. We'll delegate to the concerned officer.
It will be better if the PCCF himself does it,
Very well, your lordship, very well. Very well. You can,
or you want to go to DFO?
DFO would be more convenient.
DFO will be more convenient for the people residing there. Okay. The petitioners be delegated to approach the Divisional Forest Officer, Longai, LONGI, Forest Division, Karimganj, to submit a representation and all supporting documents to justify their respective claim to continue to dwell in the forest areas, forest dwellers. First one. The on such offer be made, comma, the learned counsel for the petitioner has submitted that if so directed by this court, comma, the petitioners would approach the Divisional Forest Officer, Longai Forest Division, for examination of so as to enable the said authority to examine the claim of the petitioners. To continue to reside at Solamona, SOLAMONA, Forest Village. What is NS Solamona? NS is a word.
My lord, it's named like that.
Okay. It was just like N full stop, S full stop, Solamona Forest Village, comma. Then number 2, Old Solamona, SOLAMONA, Forest Village, comma. Number 3, Shambhu Nagar, SHAMBUNAGR, Forest Village, under Longai Reserve Forest. However, comma, it is submitted that as the petitioners apprehend their imminent eviction from their households, comma, it submits that the petitioners be protected for some time till they approach the jurisdictional Divisional Forest Officer. Stop. Consider the submissions made by both sides. Hence, comma, without observing anything on the merit of the writ petition, the court is inclined to close this writ petition with liberty to the petitioners to submit a, what is called, it will be petition or an appeal or representation, what?
I think it will be a representation.
So submit a to submit a representation before the Divisional Forest Officer, comma, Longai Forest Division, to justify their continued residence in the 3 forest villages referred herein before, and to file all relevant documents before the said authority on which they intend to rely. First on, the petitioner shall approach the said authority within a period of 2 weeks from today. 2 weeks is okay?
Okay.
Within 2 weeks from today. And on receipt of such representations, comma, the Divisional Forest Officer, Longai Forest Division, within bracket respond number 3, shall provide an opportunity of personal hearing to the petitioners and decide the decide on the said representations within a period of
6 weeks, your lordship.
within a period of 6 weeks from the date of receipt of such representations. Full stop. Next, we are taking note of the projection made in this writ petition that the petitioners claim to be residing in the forest area. In accordance with the provisions of, where is that, 70 years, after 3 generations or 70 years, where is that?
That is in
Scheduled tribes and traditional, other traditional forest dwellers act.
Which provision?
The definition of other traditional forest.
They're claiming that they have been residing within the forest area for more than 75 years or 3 generations as provided under section 2 within bracket O of the scheduled tribes and other traditional forest dwellers within bracket recognition of forest rights bracket close Act 2006. As well as policy decision of the Government of India, Ministry of Tribal Affairs for conversion of forest villages, old habitations, unsurveyed villages, etc. into revenue villages under section 3 within bracket 1 within brackets small h brackets of the said act. The court is inclined to provide that till the representations of the petitioners are not heard and disposed of, the petitioner shall, the jurisdictional divisional forest officer, Longai Forest Division shall not evict the petitioners without leave of the court. Next, with the first of the on terms as indicated above, this representation stands disposed of. The petitioner shall produce a certified copy of this order before the respondent to bring the order to the notice of the said authority. Other matters I may not take up. Yes.
Item 10 lawsuit date can be fixed lawsuit. Hard on 16 lawsuit, due to urgency lawsuit, it is again fixed on today lawsuit. The matter of lawsuit, unless it was listed on a third lawsuit, and due to urgency lawsuit, have taken this today itself lawsuit. Maybe let's take another day after tomorrow lawsuit. It is a sealing of a dam lawsuit matter.
Oh, that's sealing of the dam.
Yes, lawsuit.
Okay. Day after tomorrow.
Public question.
Okay.
Obliged.